Hello, am I audible? Am I audible?
Yes, sir.
Yes,
Yes, sir.
Yes, sir.
yes, sir.
Yes, sir. Please go on. देखो
Am I audible?
Yes, sir.
Yes, sir.
Yes, sir.
Sorry, there was a technical issue. Myself, Jivan Bhosle, from Team BVKS.
Sir, you are on mute.
Sorry, friends. I am starting again. Myself, Jivan Bhosle from Team BVKS. I want to welcome you all for this wonderful session on HR legal organized by Bharatiya Bima Karmachari Sena and Mumbai Insurance Institute. I want to say thanks to our beloved leader, Dinesh Bhau Bovate, Sachinji Loke, and office bearers of Mumbai Insurance Institute. I also want to thanks to my colleagues, Anil Ji Jadhav, Prasad Sakarkarji, Sagar Deshmukhji, and Satish Kiradkar Sirji. Our today's faculty is Hanif Sheikh sir. Sir is stalwart of in HR legal and vigilance. Sir has vast experience of more than 40 years in vigilance department. When there is an vigilance issue, management of all coal companies has to call Hanif sir for solution for the same. Sir has helped many employees in his tenure, and after his retirement also he is helping employees. Sir has vast knowledge in vigilance and HR legal. Now, taking further time, I request sir to take over and start his session. Thank you.
Good morning, friends. Can you hear me?
Good morning, sir.
Yes,
sir.
Good morning, sir. Yes.
Okay.
Yes, sir. You are.
Yeah. So today's topic is HR legal. So mainly I'll be dealing with IDD and vigilance cases. So I mean, this course has been condensed to an extent that when you will be appearing for the examination, it will be easy for you to understand the subject and answer the questions. And you see, this session has been divided into two parts. First, I'll be taking the theoretical part. I will explain you the rules and regulations, and subsequently there will be one session which will be fully devoted for questions and answer, where you will be shown some question and the answers will be also appearing on the screen. You will have to give the answer, so that time you can unmute your mobile and answer. So we start with that. So we know that in all sphere of our life, we are governed by certain rules and regulations. Likewise, supposing if you are driving the car from which side of the road, you drive the car from the left side of the road. Why? Because the rules of the country is like that. Now, supposing if tomorrow you go to US, then you will be required to drive from the right side. So that is your you need to follow the rules and regulation of that particular company. The same way, you are also governed by certain rules and regulations of the company. So what are those rules and regulations? Yes?
Loki, come eat.
Hello, can you hear me?
Yes, yes.
Yeah.
Eat. ये थोड़ी खिलाया था तुमने मेरा आवाज ही नहीं आ रही है
चेंज होता नहीं साइड का चेंज so see, we are all governed by rules and regulation, whatever department you are working in. So there are certain rules and regulation of that department. Maybe you are working for underwriting department, so it is there are certain rules and regulation and which you have to follow whenever you are underwriting a proposal. Same way in accounts department, in claims department, in IT section, in HR, like that. So we are governed by certain rules and regulations of the company. So there are set of order and obedience. So various rules and regulation in respect of various department you need to follow. Now, supposing if you deviate from those rules and regulations of the company, if you violate those rules and regulations of the company, if you contravene those rules and regulations of the company, if you show disrespect to those rules and regulations of the company, if you are showing utter disregard to those rules and regulations of the company, if you are negligent, careless in performing your duties, if you are non-adhering to or non-observing the rules and regulations of the company, it will be termed as misconduct. So you understand what is misconduct. So you must be wondering why I have used so many words. Likewise, definition, violation, contravention, showing disrespect, utter disregard, negligence, carelessness, non-adherence, non-observance. This is nothing but a misconduct. Now, misconduct can be of two nature. One can be of administrative nature and the other can be involving a vigilance angle. So administrative lapses means what? Now, supposing if a person is not attending the office regularly or he is not submitting the application, he is having a fight with the other colleague in the office, he is smoking in the office premises. So these are all administrative lapses. But supposing if a person has committed a misconduct by virtue of which either he is trying to gain himself financially or he is trying to pass on some undue financial benefit to others and there is a financial loss to the company. So that will involve a vigilance angle. So this is also misconduct. So now you must be knowing what is misconduct. One will be of administrative lapses and the other one is involving vigilance angle. Now these rules, CDA rules are applicable to whom? That always a question comes. So these rules are applicable to all employees. All employees means right from sub-staff or PTS to CMT. And exception is whom? Officers on deputation from all India service, central service or state services. You must be knowing that there are certain people who are working with our organization. They are not they don't belong originally to our organization, but they have been deputed from other companies or other central services or state services. So these rules will not be applicable. But since they are performing their duties in our organization, and supposing tomorrow if they commit a misconduct, yeah, that doesn't mean that they will be scot-free. I mean, no action can be initiated against them. The only thing is that their company's or their parent company's CDA rules will be applicable to them and they will be tried for the particular misconduct committed by them under their CDA rules. And the other exception is casual employees. You know, casual employees, they are not our regular employees. Supposing if you are a branch manager, divisional manager, and in your branch or divisional office, one day the sweeper doesn't come, then you cannot keep the office unclean. So you need to clean the office by employing someone. So he will be called for performing that particular job. And once the job is over, so he will be given some sort of a payment which has been agreed. And so there is no need to try him under CDA rule. Supposing tomorrow, if he fails to perform his duty up to the satisfaction of the management, so he can be very well asked not to attend to that work, and from next day he should not come to office. Now we know what are the misconduct and what rules are applicable. To which employees these CDA rules are applicable. Now, supposing if a person has committed a misconduct, That means he should not be left like that only. Some action will be taken against him. Now, depending upon the gravity of the misconduct, either minor penalty or major penalty proceedings can be initiated against him. So what is minor penalties? That is under rule number 23. There are 1, 2, 3, 4 type of penalties. First is censure. Censure means what? Supposing if a person has committed a misconduct and the management feels that this is not causing any financial loss, but that is he is not following the rules and regulations of the company, and he need to be more careful and judicious in taking a decision in future. So he can be censured. But censure is nothing but a warning letter, recorded warning letter. But for issuing a penalty of censure, it is a must that a person should be issued a charge sheet that conveying the article of charge, what he is supposed to answer. And once he gives to the charge framed against him, then depending upon the gravity of the misconduct, the management can decide to censure it. So censure is a pure minor penalty. Then the other one is withholding of one or more increment for a specified period. We know that we get our annual grade increment after completion of 1 year of regular service. Now, supposing if a person has committed misconduct and for which minor penalty charge sheet was issued, and depending upon his representation, the management had decided to award him a penalty of withholding of his one or more increment for a specified period. Withholding of increment what means what? Supposing tomorrow today your basic is 20,000 rupees and annual grade increment is 1,000 rupees. So you are supposed to get your one increment. Supposing it is in January. January you are supposed to get one increment, but because of this penalty, he will not be entitled to get that increment. So instead of going from 20,000 to 21,000, he will remain at 20,000 rupees for a specified period. So that specified period can be for 1 year, 2 year, or 3 year. So that is a temporary withholding of increment. Then the third penalty under minor penalty charge sheet is recovery from pay or such other allowances for causing pecuniary loss to the company. Now, a person has settled a claim. Say now instead of settling a claim for 5,000 rupees, he has settled it for 5,500, 5,700. That may be due to clerical mistake or calculation mistake, and the management said that he has not done this with malified intention, but still there is a financial loss to the company. Then the management or the disciplinary authority has got a prerogative to recover that amount from him. So that will be also under minor penalty. Then third is reduction to a lower basic salary temporarily for a period not exceeding 3 years. Now we were talking about withholding of increment. That means the increment what you are supposed to get after completion of 1 year of your regular service. But reduction to a lower basic salary means today your salary is 20,000 rupees, and by virtue of this penalty, it will be reduced to 19,000. And supposing it has been reduced for 1 year, so if, for 1 year it will remain like that. But in between, supposing if you are eligible to get an increment, that you will be getting, and the increment which has been reduced will be restored after completion of that specified period. Might be 1 year, 2 year, or 3. Okay. Now difference between warning, caution, and censure. आवाज येतोय ना? See, because I have told you right in the beginning, for censure, it is necessary that the management has to issue a charge sheet. Without issuing a charge sheet, a person cannot be censured for his misconduct. But supposing if a person has committed a misconduct, which is not of highest thing, which is not of that grave in nature. Now, likewise, supposing if you are supposed to carry out the physical inspection of the vehicle, if there is a break-in insurance, but there is no claim reported. But as you want to educate that employee and wants him to be prudent underwriter and want to ensure that he follows that instruction of physical inspection of the vehicle in case of break-in insurance. If you come across such proposal or such case, then without issuing a charge sheet, you can warn him or you can caution him. So that is the difference between warning, caution, and censure. Now we were talking about major penalty, minor penalty. So the other one is major penalty. So major penalty means what? Withholding of one or more increment permanently. So what we have seen in minor penalty, withholding of one or more increment for a temporary period. But here your increment, what you are supposed to get after completion of 1 year will not, you will not get it forever. But after, supposing from 20 to 21,000 rupees, you will not get. But after completion of another 1 year, you will get 21,000, 22,000, 23,000, so on and so forth. So every year you will be one increment behind. Now, the colleague of yours who has joined along with you, supposing he's got 20,000 basic, yours is also 20,000 basic. Next year he will go to 21,000, whereas you will remain at 20,000. Next to next year he will be 22,000, you will be at 22,000. Same way after 10 years he will be at 30,000, you will be at 29,000. That means one increment has been denied to you permanently. Now reduction to a lower service or a post or a lower time scale or to a lower stage. Now lower service means supposing if a person has been promoted from assistant manager to deputy manager.
Sir, repeat that E again. With withholding of one or more increment permanently.
Permanent, yes. You can, you have a copy and pen with you, na? Hello? Do you have a paper and pen with you?
Yes.
So you just write down likewise A and B, A employee and B employee. Now both are on the same stage, say 20,000 rupees. Now A has got a penalty and assuming he is supposed to get this increment in the month of June 2023. Both of them are supposed to get. But A has been imposed a penalty, that is one increment has been permanently withdrawn. Okay. So in 23, his basic will be how much? 20,000. A's basic. And B, he will go to 21,000.
Next year, whenever he is eligible for increment in that month.
So first year he will not get. First year he will not get. So that is permanent reduction. So he will remain at 20,000 only, whereas B will go to 21,000. Okay. Now in 24, A will go to 21,000, whereas B will go to how much? 22,000. Same way. So every year he will be 1 year, one increment behind.
Yes. Now I understood.
You understood?
Yes.
Okay.
Thank you, sir.
Yeah. Now reduction to a lower service or post or to a lower time scale or to a lower stage. Now reduction to a lower service. Now supposing if a person has been promoted from assistant manager to deputy manager and a misconduct has been committed by him. So the management, depending upon the gravity of the misconduct, can reduce his rank. That is, from deputy manager, he can be brought back to assistant manager. Any clarity is required in this? Did you understand?
Yes, sir.
Reduction to a lower service means from deputy manager, he will be brought back to assistant manager. That is service or post. Or to a lower time scale. Pardon? Or to a lower time scale. Now, what is meant by lower? What is meant by lower time scale? Now, we are all governed by this. 1 minute. Hello.
Yes.
Sir,
Sir, there is a network problem, sir.
Hello. Can you hear me?
Echo is, sir.
Sir, I have a question. Reduction to lower time scale means that only the designation also will change, or only the monetary benefits will change. Hello.
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 Can you hear me?
Can you hear me?
Yeah.
You can hear me?
Yes, yes, sir.
Yes, sir.
So what is reduction?
What is reduction?
What I was trying to tell you is that a reduction to a lower service or lower post, that you understand, from deputy manager to assistant manager to a lower time scale. Now, supposing if you are already reached a basic of 20,000 rupees after getting 4-5 increments, so you can be brought back to the lowest in the stage also, or 19,000, 18,000, 17,000, 16,000. That's depending upon the gravity of the misconduct and and the penalty which has been decided by the manager. So now, supposing if a person is on 20,000 rupees, likewise say you can, write down again 20,000, 20,000. One person will be reduced to 19,000 and the other person will be at 20,000. Now next year when increment will be given, so he'll come from 19 to 20 and he will go from 20 to 21. So always he will be one stage behind. So you understood? Hello.
Hello, sir. Miss that if becomes senior assistant, then that senior assistant pay scale will be applicable to that person.
Yeah, correct. Yeah, but before that, I would like to tell you, supposing if a person has joined in a particular cadre, say supposing if he has if he has joined in the cadre of an officer, so he cannot, his rank cannot be reduced to assistant. That will be within class only. But supposing if a person has been promoted from class 3 to class 1, then from class 1 he can be brought to class 3 also. But if he is in class 1 only, then his service, his lowest post can be within that scale 1 only. Officer scale only.
But scale 3 becomes scale 2. Means scale 2 pay scale will be applicable to that person.
Yeah, and the disciplinary authority will indicate at what basic he will be fitted in that cadre.
Okay, sir.
Yeah. Now
Thank
this is
you.
compulsory retirement, removal from the services and dismissal. This is nothing but you are no more with the organization. Now there will be a question that why then this compulsory retirement, removal from the service and dismissal, these 3 penalties have been written under CDA rules. But this carry one meaning only, that you are no more with the organization. So these are the penalties which are major penalties. Slide change. स्लो है का फ्रेश करो Now process for imposing minor penalty. See, tomorrow if I am a disciplinary authority and I don't get along with one of my officer or with my assistant, senior assistant, record clerk, sub staff. So on my own, just I want to harass him, I cannot impose a penalty on him. So for imposing a minor penalty, issue of charge sheet is a must. What is charge sheet? It is containing the allegation which you are framing against one particular employee. So that is article of charges are conveyed to that particular employee, and he has been asked to give his explanation. That is what we call written statement of defense. Now, depending upon his written statement of defense, the disciplinary authority will take a decision either to impose a penalty or to exonerate him or to let him go off by way of a just warning letter. But that all depends upon the written statement of defense what has been given by the charge sheeted employee. For imposing a minor penalty, issue of charge sheet is must. Then you need to take the written statement of defense from the charge sheeted employee. Then disciplinary authority has to take a judicious decision in deciding upon the quantum of punishment to be meted out to that employee. So here, what is the difference? And what you feel? Have you heard about the major penalty? Hello. Have you heard
Yes,
about
sir.
major
Yes, sir.
penalty? Yeah. So in minor penalty, there is no oral inquiry required. That means there is no need of appointing an inquiry officer, presenting
Hello?
officer where, yeah.
सर एक मिनिट सर सेन्सरचा काय परिणाम होतो का प्रमोशन वरती इफ
ते बोलतो ना मी
Sensor-
आता सगळं एकाच वेळेस कसं बोलतो येईल ना ते दॅट रिगर इफेक्ट ना दॅट आय विल एक्सप्लेन इट
ओके सर
that is in our syllabus only, so don't worry. So for issuing for imposing a minor penalty, charge sheet is a must. Only thing is that there you don't have to go for a oral inquiry. म्हणजे आपण inquiry करतो ना, inquiry officer attend करतो. Okay, so whenever we want to impose a minor penalty, so it is necessary to issue a charge sheet. Without issuing a charge sheet, you cannot impose a minor penalty. And after receipt of written statement defense, then only the disciplinary authority can decide about the imposition of penalty. But here in minor penalty, there is no need of bringing the witnesses and all, and no need of appointment of inquiry officer and presenting officer. You understood this? Okay.
Yes.
Now procedure for imposing major penalty. So now the charge sheet has to be issued. Charge sheet has to be issued. Then depending upon the his reply, the management will institute a departmental inquiry. Why it is called departmental inquiry? Because this is an in-house inquiry. Then they will appoint an inquiry officer and presenting officer. Then the inquiry officer can be officer of the company, or he can be a public servant, or can be a retired officer of the company. So normally a question comes, who can be appointed as an inquiry officer? So officers of the company, public servant of the company, then retired officer of the company also. Now I have explained it to you what is minor penalty, what is major penalty. First of all, what I have explained to you is what is misconduct. Misconduct can be of two nature, that is administrative, and the other one involving vigilance anger. Now, supposing if the charges of grave in nature or minor in nature, the minor penalty or major penalty will be issued. For minor penalty, only charge sheet has to be issued, and depending upon his written statement of defense, the management can decide about the quantum of punishment to be meted out to him without conducting the inquiry. But in major penalty, you need to conduct the oral inquiry. So now these are the for imposition of penalty. These are the important points. Whether major penalty can be imposed without oral inquiry. I have given you the answer. See, for imposing. See, what I have been given to understand that one of the participant is using two instruments at a time. तो एक instrument बंद कर दो आप. So for major penalty.
Resound वाले से okay ना?
So for imposition of major penalty, oral inquiry is a must. So whether major penalty can be imposed without oral inquiry? Somebody has to answer.
No.
No, correct. Why? Because for imposing a major penalty, it's necessary to have an oral inquiry.
No, no, sir.
They mute us. So now whether minor penalty can be imposed for major penalty charge sheet. Now major penalty has been issued, but the management wants to impose a minor penalty. Whether it can be done.
DL Gupta needs to.
Pardon?
Sir, DL Gupta needs to mute.
Hello, can you hear me?
Yes, sir.
So now whether minor penalty can be imposed for major penalty charge sheet. Yes. See what happens now once the charge sheet has been issued, that time the management felt that it was a grave mistake, misconduct on the part of the delinquent employee. But what has happened subsequently during the course of the inquiry, it transpired that he was not directly responsible for that. But as a member of the DCC, or he forgot to, or he has or supposing if the misconduct is not that serious, so the management can decide about imposing a minor penalty, though the charge sheet for major penalty was issued to him. Same way, whether major penalty can be imposed for minor penalty charge sheet. No, because we have said once the minor penalty charge sheet has been issued, the penalty has to be necessarily from the minor penalties only, that is 23 AB CD. Why? Because if a person has to be imposed with a major penalty, then major penalty charge sheet is required to be issued to him, and he should get an opportunity to defend himself before an independently appointed inquiry officer. Whereas in minor penalty, we have said that there is no need of tendering oral evidence. So for minor penalty, only minor penalty, minor penalty charge sheet, only minor penalties can be imposed, not major penalties. See, I'm requesting all of you not to start your mic. So whatever queries you have got now, you just note down. And after I finish this theoretical part of this presentation, I will give you an opportunity to ask me, because what has happened now, someone from your side now, he's kept his two instrument in operation. So therefore now I'm getting this echo sound, and I'm unable to concentrate properly. Okay. Now there are various proceedings. Now rule number 29, that is common proceedings. Now you will be wondering what is common proceeding. Now supposing if a claim has been settled by a DCC members and it has not been settled properly, there are certain glaring mistakes, discrepancies in settlement of that claim, and for that the management had decided to charge it all the three employees, that is chairman, then DCC members, and including the person who has processed that claim. So instead of calling one witness for during the course of inquiry of one employee, one common proceedings will be conducted, wherein all four charge sheeted employees will get an opportunity to cross-examine the witness, and a witness will be called only once. So whatever question has to be asked to him by the presenting officer will be asked in front of all the four employees, and all the four employees will get an opportunity to cross-examine. So this way the time is saved, and that witness is also not required to come frequently for giving his oral evidence. Then rule number 30, this is common proceeding. The other one is rule number 30, that is special procedure. What we have said, supposing if a person has to be imposed with a major penalty, then necessarily the charge sheet has to be issued. But there is an exception to this rule, and that is mentioned in under rule number 30, that is special procedure. Now, if a person or if an employee has been convicted for committing a criminal offense involving moral turpitude, and he has been ordered by the court to undergo a rigorous imprisonment of 2 years. For such employees, there is no need of issuing a charge sheet. They can be straightway dismissed from the services of the organization by invoking the provisions of rule number 30, that is special procedure. And abandonment of services. What is meant by abandonment of services? Now, if an employee is remaining absent from the office without intimation, without sanction, without sufficient due to his credit, without submitting application, without knowledge of the his superior, and he continues to remain absent from the office for more than 30 days. So without issuing him a charge sheet, he can be dismissed from the services of the company by invoking the rule number 30 of the CDR. So for imposing a major penalty of dismissal, the inquiry proceeding is not required under rule number 30 if a person has been convicted on criminal charges or he has abandoned his services. That means he has remained absent from the office for more than 90 days without intimation, whatever I have already explained. Then the other one is ex parte proceedings. Now, ex parte proceeding means in inquiry there are three parties. One is inquiry officer, the other one is presenting officer, and third one is the delinquent employee or charge sheeted employee. Now, normally what happens, the charge sheet employee tries to delay the inquiry by giving all lame excuses. So so what happens, the inquiry, the purpose of initiating the inquiry gets defeated. Because as per CVC guidelines, we are supposed to complete the inquiry within 3 months of appointment of inquiry officer. Now, if he takes some pretext and takes the adjournment of the inquiry or try to postpone the inquiry, so it can be given only thrice. Barring medical, supposing if he has submitted the medical certificate that is unable to attend because of his sickness, then only you can't do anything. But supposing if he's saying that I'm going for wedding, I'm going for some function, I'm going on LTS. So on 3 occasions, you can give adjournment, but on 4th occasion, you need to conduct the inquiry proceedings ex parte. Ex parte means what? The presenting officer will present the case before the inquiry officer through deposition of various witnesses and documentary evidence. After those documents and oral evidence has been adduced, then supposing inquiry officer wants, he can ask the questions to the charge sheeted employee. That way the inquiry will get over. So this is called ex parte proceedings. Now concurrent inquiry proceedings. So you know that we are all public servant. We are all public servant. Tomorrow, supposing if we settle one claim wrongly and because of that the financial loss has been caused to the company, or you have derived some financial loss, or you have tried to pass on the financial gain to some other person, then the case can be registered against you in under CBI. And simultaneously, if the management wants, they can initiate action under you under CDA rules against the same employees. So at a time, you will be subject to CDA rules of the organization by initiating a RDA measure against you, and similarly, the CBI will register a case against you. So that will be tried under the criminal proceedings rules, and ours will be tried under CDA. So both the inquiries can go simultaneously. But mind it well that the decision of either disciplinary or internal inquiry or the court's verdict will not be binding on each other. Now tomorrow, supposing if the charge sheeted employee has been exonerated by the office, but CBI will say, no, we are going to try him, and that decision will not have any bearing on the decision of the management. Same way, supposing if the CBI has exonerated. So CBI must have exonerated him under criminal proceeding rules. But since there is a violation of our CDA rules, he can be tried by our organization and suitable penalty can be imposed on that. Now, outside employees, outside employment, that is CDA rule number 6 and 7. Say employees not to seek outside employment without previous sanction of the competent authority. It means the company have given you an opportunity to work outside also, provided you get a previous sanction of the competent authority. So that means what? See, supposing if I want to do some part-time work, I will make an application to the my seniors or the RO official seeking their sanction. And if they are given please mute your hello. Please mute it. आपके माइक म्यूट कर दो. Okay. So now management will give you an opportunity, will give you their sanction to work you for allowing you to work on part-time basis. But there is a catch in it. Now, in such cases, as per CDA rules, if the honorarium or the remuneration, whatever you will be getting by working out on part-time basis, that entire amount you will be required to deposit with the with your company, and the company management will take a decision how much has to be appropriate between you and the company. Likewise, supposing if you are drawing 10,000 rupees by working on part-time basis, 10,000 rupees you will deposit with the organization, with your company, then company will say, okay, we'll distribute 50% amongst us. So therefore, the people, they don't take any sanction from the office. And for taking any part-time job, you need to take the prior permission. But I have told you, since there is a complex issue in treatment of the fees received, therefore the people, they don't go for seeking the permission of the competent authority. Now, leave rules. We all know that we are getting casual leaves, we are getting privileged leave, we are getting sick leave. But leave you cannot take as a matter of right. Means what? Just I have got my 240 days balance in PL and I want to go for, I want to take 10 days. So unless and until you submit an application and your boss is satisfied that during your absence, this work can be handled by someone. And if he says that there is other staff also who is capable of carrying out your job, so he may allow you and he may disallow you also. Now, supposing if a divisional accountant wants to proceed on privilege leave in the month of March, so no divisional manager, no branch manager, no regional office officials will permit such person to proceed on leave. And supposing tomorrow, if we proceed without seeking an application, without submitting an application and seeking an approval, so his entire leave can be treated as leave without pay or unauthorized leave, though he's got a sufficient leave to his balance. Then, see, you can proceed on leave for a 1 day, that is scheduled leave. For a 1 day scheduled leave, for that prior permission is not required. But you need to submit your application the day you resume your duty, giving the reason for availing that particular 1 day CL. Now we see our office timing is 10, but people, they are attending office at 10:30. So therefore, it has become that our office timings are 10:30 onward. But still, supposing if a person has been marked, say if he attends at 10:35, and such late attendance is resulting into 3 occasions, 3 times in a month, either he comes late or leaves early from the office. So his half-day CL will be forfeited. That means half-day CL will be debited against his name. Then you cannot leave your headquarters without prior permission. Now, what is your headquarters? Now, supposing if I belong to Pune and I am posted to Mumbai, so my headquarters is Mumbai. But you will find that most of the people, those who have been posted in head office Mumbai and they are from Pune, so they naturally come to Pune on Saturday, Sunday. But since their headquarters is Mumbai, so before they leave their headquarters, they need to inform their immediate boss. Now you'll be surprised why this rule has been made. See, tomorrow something unforeseen or unfortunate event happens. So the management should be in a position to know about your whereabouts. Therefore, this rule has been. Now, competent authorities. Now, competent authorities, have you gone through your CDA rules? Have you got the CDA rule books? Now, if you see the last pages of the CDA rule book, now there you will find the competent authorities. That is Schedule B, which shows various authorities, that is appointing authority, disciplinary authority, and appellate authority. So, who is appointing authority? Who has got authority to appoint you, and who is the disciplinary authority who can initiate major or minor penalty action? Authority means to whom you can prefer your appeal being agreed by the order of the disciplinary authority by virtue of which you have been imposed a penalty. Now, please note that the penalty of dismissal, termination, or removal can be imposed by appointing authority only. Now, for assistant, if the disciplinary authority is assistant manager, and the charges leveled against him are proved, and those are of grave nature. Likewise, he has misappropriated a premium of 5 lakhs, 10 lakhs rupees, and that warrant dismissal from the services. So that time you need to ensure that the appointment letter of that assistant has been signed by whom. Supposing it has been signed by deputy general manager, so his termination or dismissal or removal will be signed by only that deputy general manager or the person who has appointed him in the organization, not that particular person, but that designation. So please note that whenever the penalty of dismissal, termination, or removal has to be imposed, it has to be imposed by the appointing authority. This question normally comes.
Sir, what about suspension?
Yeah, everything I'm taking, madam. You are in a hurry to close down. I mean, get this session over or what?
No, sir.
You don't worry. Everything is there. I will give afterward. Also, I'll give an opportunity to talk to me if I have missed some topics. But I'm sure I will not miss a single topic. Okay. Now, appeal. What is appeal? See, now the penalty has been imposed on you by the disciplinary authority. Normally, what happens the moment the penalty comes, that person will plead his ignorance. अरे मैंने तो कुछ भी नहीं किया, मुझे जबरदस्ती penalty दिया है वगैरह. Then he will agree by the order of the disciplinary authority. Then, in that case, likewise in court, what happens? The lower court imposes a penalty. Then we make an appeal before the high court. And even if the high court verdict is not in our favor, then we go to Supreme Court. In the same way, in our organization also, we have got this appellate authority and memorial authority. So first, you are agreed by the decision of the disciplinary authority. So you will be preferring an appeal before the appellate authority under rule number 31. And for that, you get 90 days of time to submit your appeal. But that 90 days will commence from the date on which you have received the order of the disciplinary authority. Now, supposing if the order has been signed by the regional office and a person is working in divisional office, which is 200 kilometers away from the RO, so it will take 2-3 days to reach that office. Then, depending upon the availability of the concerned person there and the divisional manager, that will be handed over to him. The day he will be getting that copy, he has to sign it under date. We have to mention the date also. And from that day, 3 months will be given to him for preferring his appeal. Now, once you prefer your appeal, so what decision will be taken by the appellate authority? Likewise, in High Court, what it happens, supposing if your appeal, they are in agreement, whatever points you have raised, so you can be let off, or you will be exonerated, or your penalty will be decreased, or so it may so happen that your appeal will be rejected also. But in some of the cases, it has happened that supposing if the disciplinary authority has imposed a certain penalty, that can be also increased. So during appeal, see, appeal has to be made within 3 months. 3 months from the date of receipt of this order, and once you submit the appeal, either be rejected totally or the decision of the disciplinary authority will be modified. That supposing 4 increments has been reduced, so instead of that only 3 increments or 2 increments. Or supposing if the management feel or the appellate authority feels that the penalty is not commensurate with the misconduct committed by that particular delinquent employee, so they can enhance also the penalty. But before enhancing that penalty, they need to inform their intent that they are going to increase the penalty, and therefore you will get an opportunity to represent your case. Now, memorial, we have come from session court to high court. Now, from high court, we are going to Supreme Court, that is memorial. So, if the appeal of the employee is rejected, then he can make a memorial before CMD under Rule 40 within 6 months from the date of receipt of the order. Now here I have written CMD because most of the employees, they will fall under their memorial will be before CMD, but manager and above, that is scale 4 and above. Scale 4, the disciplinary authority is general manager and appellate authority is CMD. Therefore, that will go to subcommittee of the board and board of directors, like that. So you need to look into that Schedule B. So different authorities are given in schedule about as to who can be who can consider your member. Now suspension. Now what is suspension? In a simple word, I can tell you suspension is not a penalty. It's a temporary. What do you call? I mean, you are not allowing an employee to work in the office from where he has been suspended. That is temporary suspension of his service contract. It is not legally correct, but to understand us, we can say that his services has been temporarily suspended. So a person can be suspended under Rule 21 if a disciplinary proceeding is contemplated or pending against an employee. Means what? Supposing if a person has committed a misconduct, say the prima facie the evidence suggests that he has misappropriated a premium of rupees 5 lakhs. 5 lakhs. So what management will do? He will be placed under suspension. Why? Because there is always a chances of record being tampered. Supposing if he is continue to work in the same office. One. Secondly, where case against him in respect of any criminal offence is under investigation or trial. Now, what happens? A person uske against any, supposing if there is any criminal offence which is under trial, and you know, because we are public servant, so we should not have any criminal background. So in that case, also management can place you under suspension. So there are two circumstances under which a person can be suspended under Rule 21. That is, if any disciplinary proceedings is contemplated or pending against an employee, or where a case against him in respect of any criminal offence is under investigation or trial. Now, what is deemed suspension? Sometimes what happens now, we have got some employees, they do some sort of a criminal offence and they are caught by the police and they are detained in the police custody. And after 6 months, they come and appear before us and we don't know whether where they were. And in between, one of the well-wisher of that particular employee, he informs us that he was under detention for 6 months. Then what we have to do about that 6 months? So even though he has joined the duties, but the day he was arrested and the day he was released on bail, that period will be called as a suspension. So we have supposed to have placed him under suspension, that is deemed suspension. But in that also, now supposing if a person has been detained and the custody is not exceeding 40 hours, then he cannot be placed under deemed suspension. Now what happens? A person has been caught by the police on Friday. Saturday, Sundays are holidays and he is produced before the court on Monday. That means more than 48 hours are already over. So whether he can be can be deemed to have been placed under suspension? No, because he was brought before the judicial magistrate on Monday and he was granted bail. Had he been brought before the magistrate on Saturday, he would have got the bail. But because this intervening period was holiday, he could not be produced. Now, had it been caught on Monday and produced before the judicial magistrate on Tuesday, he would have got the bill. So that 48 hours will not take into consideration the intervening holidays. Okay. Now suspension can be revoked by the authority which has passed the order earlier. See, suspension, I have already told you, this is not a penalty, so there is no question of a disciplinary authority. See, the authority who has placed him under suspension after some time can think that since he has been placed under suspension, he is getting subsistence allowance, he is getting 50% of the salary without doing anything. Instead of that, I will revoke his suspension period and I will ask him to join at some different place. So the suspension can be revoked by the authority who has passed the order of suspension. Now, subsistence allowance. Now, I have told you suspension is not a penalty. Neither we have issued him a charge sheet. हम उसका action भी कुछ शुरू नहीं किया है. So in that case, what is his fault? Only that we suspect that he has committed certain misconduct, and for that we are not allowing him to attend the office. Then how we will survive? What about his family and children? So therefore, there is a rule number 21 which says that 50% of the monthly gross emoluments for 6 months of suspension will be given to the suspended employee by way of a subsistence allowance. That means a person has been placed under suspension, say on 1st of July. So till 31st of December, he will get 50%. Now, after 31st of December, sorry, 1st of July to 31st December, that is for 6 months, you will get 50% of the monthly gross emoluments. Now, after 6 months, now supposing if he is not cooperating in conducting the inquiry or completing the inquiry, so whose fault is there? That the fault lies on the employee himself. Therefore, we will reduce his subsistence allowance from 50% to 25%. But assuming the management is unable to complete the inquiry proceedings or conduct the investigation, so that time he will be entitled to get 75% of the subsistence allowance. So there are three circumstances. First, the moment he has been placed under suspension, he will be getting 50% of the subsistence allowance for 6 months. If he is cooperating with the management and the management is unable to complete the inquiry, then we will have to increase his subsistence allowance to 75%. But he is not, cooperating in completing the inquiry proceeding, then it will be reduced to 25%. And the third and most important is that supposing if a person has been detained under police custody and it is more than 48 hours, that means he had committed some criminal offense. So therefore, he will not be entitled to get any subsistence allowance. Treatment of period of suspension. That is rule number 20. See, I have told you, can he, at the time of placing him under suspension, we were not knowing whether he is a guilty or not guilty. But afterward, when the inquiry gets over, when the police investigation gets over and he gets acquitted honorably, so that time, see, he was getting a salary of 20,000 rupees. We were paying him 10,000 rupees or 15,000 rupees as per the circumstances what I have already told you. Now he has been acquitted honorably, so he will be entitled to get the difference between his full salary and subsistence allowance, whatever has been paid. Then he was not on duty for say 1st of July to 31st of August. Say for 2 months he was not there. But afterward he has been acquitted honorably or he has been exonerated. So that period will be treated as if he has spent on the duty. That means there won't be any break in his service. Even those 2 months we'll have to assume as if he was under service. Now, assuming that he has been convicted or he has been imposed with a major penalty, that means the decision of the management to place him under suspension was right. But we have already paid him subsistence allowance. But mind it well that this will under no circumstances will be recovered. So what I have told you, suspension first 6 months 50%. Next 6 months, if he is cooperating and management is at fault, then it will be 75%. If he is not cooperating, then it will be 25%. If he has been under police custody or judicial custody, no subsistence allowance will be paid. If he has been acquitted honorably, so difference between his subsistence allowance and salary will be given to him. And even his period of suspension will be deemed to have been treated as if he has spent on duty. And if he has been convicted or if he has been imposed with a major penalty, under no circumstances the subsistence allowance will be recovered. Now, defense assistant. See, I have told you court mein kya hota hai. One is judge, the other one is public prosecutor, the third one is defending advocate. In addition to that, in our organization, we have inquiry officer, presenting officer, and delinquent employee or the charge sheeted employee. Now, supposing if the charge sheet employee is unable to defend himself properly, so likewise in court we are trying to hire an advocate. So here we cannot allow him to hire an advocate, but we can ask him to name one employee of the organization. He can be part-time sweeper to CMD also. So whosoever he wants to be to get himself defended, first of all he should intimate that name. Then he should get the permission from that employee that he will be his consent has been given to work as an defense assistant. Then secondly, that defense assistant should not be acting as a defense assistant in more than 2 cases. And he should be from the same region from where this employee is charge sheeted. See what happens now, supposing tomorrow, by virtue of my experience, I want to be a defense assistant, but management has employed me as a divisional manager, but I've got a very good knack of defending the people and I'm posted in Chandigarh. So what will happen now, all people from across India will try to avail my services, and I'll be ending up with just giving my services as a defense assistant, which is not correct. So therefore, the management has taken a decision that a defense assistant can be acting in a cases for two cases at a time. Same way, he cannot be from the other region also. If Pune region ka hai, to Pune region ka hi aadmi chahiye. If he is from Chandigarh region, so the defense assistant from that Chandigarh region. But supposing in one area there are more than 2-3 regional office or LCBO. Likewise in Pune, we have got Pune RO and LCBO. In Mumbai, there are 5 regional offices and n number of LCBO. So that particular city can be considered as one office. But Mumbai person cannot appoint a defense assistant who is from Pune, Ahmedabad, Baroda or any other region. Secondly, he should be an employee of the organization, not even retired employee, not even an employee of United India, Oriental or National. He should be an employee of New India only if a person is from New India. I mean, the charge sheeted employee is New Indian, so then New India employees. Then legal practitioner cannot be engaged as defense assistant. You cannot hire the services of a legal or a lawyer to help you in defending your case in a disciplinary proceedings. Now, if I'm a defense assistant, I'm from Chandigarh and the case is from Pune, but that employee insists that I need that person from Chandigarh as my defense assistant, then management can allow that defense assistant to come to Mumbai to act as a defense assistant, but that time he will not be treated as an official duty. So he will have to spend his money, his staying, lodging, traveling, everything will have to be borne by that person. Now, recent amendment to CDA rules. Now, Rule 422, no employee shall indulge in any act of sexual harassment or any of any woman at her workplace. See, actually, this is a very serious offense or the violation which our employees are committing. See, I request all of you that we need to respect our female colleagues. Likewise, how we respect our mother, sister, daughter, wife. So likewise, we should not be passing any unnecessary comments against our colleague female employees. So, if anyone is caught in this, take it in writing from me. No mercy will be shown against him, because I know some senior divisional manager, they have been removed from the offices under these rules. Now, pension rules. Now, whosoever is entitled to get this pension, that is pension is subject to good conduct. Means what? Not during the office, not during your service period. Even after you retire, you need to have a good conduct. Tomorrow, supposing if a person has been convicted, subsequent to his retirement, he indulged himself in some criminal offense involving moral turpitude, and he has been convicted. So that time the management has got to either withdraw his entire pension or withhold his some part of the pension. Then, supposing if a person is guilty of grave misconduct under Rule 43 of pension rules. See what happens now, a person retires. Then he start getting the pension. And after 4 or 5 months, some misconduct which he has committed during the course of his employment with the organization comes to the knowledge of the vigilance officer or the manager. So that time, if that misconduct is grave in nature, and from the commission of that misconduct 4 years are not passed, then management can decide to take action against him under pension rule by invoking the provisions of rule number 43. Now this 4 year is not from the date of his retirement, it is from the date of cause of action. Supposing if a claim has been settled, say on 1st of January 2019. So 20, 21, 22, 23, I mean 1st of January 2023, the 4 years are over. So no action can be taken against him. But if he has committed a misconduct at the time of his, his retirement, say in 2022, and 24 you come to know. So these are only 2 years. So the action can be taken against him. If you are not understood this, you can ask me subsequently also. Now provision pension will be paid. Now what happens now? A person has been charge sheeted and his inquiry is going on. So when his inquiry is going on, so what happens? He will not be getting his pension because it has not been decided, it has not come to the fore or the knowledge of the organization through the submission of the inquiry report that whether he is guilty or not guilty. So he will be getting provisional pension. Now provisional pension is nothing but a full pension. That means he will not be allowed to commute his pension. Now if his basic comes to 30,000 rupees, his basic is 60,000 rupees. So pension for pension calculation purpose, 1/2 is considered, that is 30,000. Out of that, he is allowed to commute 1/3, that is 10,000. So instead of allowing him to sell his 10,000 rupees, he will be given 30,000 rupees, his basic pension plus DA, whatever is applicable. And only after the result of the inquiry is known, that it will be decided whether he will be allowed to commute his pension or whether his pension will be stopped because he has committed a grave misconduct. Now, supposing tomorrow if he is found guilty, so his gratuity will not be paid, but his PF has to be paid. His encashment of leave is also paid. PFC, that is our own contribution. So by virtue of order of any tribunal, forum or court, it cannot be withheld. So PF will be getting, encashment of leave he will be getting, gratuity will not get, but there are n number of cases that if the employee approaches the court, so court gives the necessary direction to the company to release his gratuity. Now supposing if you are, and VPF is also there, you are opted for VPF also. So that time also, your VPF cannot be withheld by the company. Now, if you are getting a company's contribution towards provident fund, since that is a contribution made by the company, so that cannot, company has got a right to withhold that. Now, all employees are required to submit their annual property returns by 30th of April every year, giving description of property acquired, sold by them during the preceding year. So every year we are supposed to submit our property return. I hope every one of you must be submitting this property return because that has been made mandatory. Earlier it was offline, now online we need to submit. Only thing is that we are supposed to submit it on 30th of April. That is after passing of the financial year, 1 month's time you get, wherein you have to give the description of the property acquired or sold by you during that period. And there are n number of information what you are supposed to share with the organization. I hope you must be doing that. Next. Now, Central Vigilance Commission. Do you know that one Central Vigilance Commission is there? So all public sector organization get the direction from the Central Vigilance Commission, where they have got a separate advisor for banking sector, for insurance sector, like that. So earlier now, people who were, or the officer who were in the cadre of scale 3 and above, their cases were going to CVC for seeking their advices. That is seeking their advices for imposition of penalty, initiating of penalty proceedings also. But from September 2000, officers in the cadre of chief manager, that is scale 5 and above, are coming under the purview of the CVC. So now, supposing if a misconduct has been committed by a chief manager, regional manager, deputy general manager, or CMD, the report will be given to the Central Vigilance Commission, and the Vigilance Commissioner will decide what further course of action has to be initiated against that erring official. Earlier it was deputy manager, that is scale 3. Now it has been made to scale 5 and above. So normally one question comes. Now, sanction for prosecution. I've already told you that we are the public servant. So before any action is taken by the CBI against us, the disciplinary authority has to give consent to initiate action against us. So disciplinary authorities' roles come into picture. Now, supposing if a claim has been wrongly settled and that came to the knowledge of the CBI, and CBI has conducted an investigation and they have submitted the report to us, stating that we want to prosecute this particular employee. So that time disciplinary authority, going on the merit of the case, very well say that this person is not directly responsible for settlement of the claim. There are surveyors and other people also. So in that case, disciplinary authority will say that we are going to initiate action against him under our CDA rules, and we are refusing to grant you permission to prosecute. So in that case, what happens? CBI and now vigilance departments, they will be facing each other. So what happens? Because CBI wants to prosecute him, whereas we want that CBI prosecution has not to be given. Then we need to place this matter before the CVC, who will act as a umpire. So in that case, we will require to make our presentation before the CVC. CBI will make a presentation before CVC, and then CVC will take a decision. Supposing CVC says that yes, CBI is correct in initiating action against him, so we'll have to agree that. If the CVC says that no action is required against the employee, then CBI has to agree. But now in 2017 or 18, there is one more circular from CVC. Now, even to investigate a case against any public sector employee, the permission of the disciplinary authority is required. Now, without his permission, now supposing tomorrow if a claim has been settled wrongly and CBI comes to know that through their sources, and they want to investigate that, but the disciplinary authority says that no, we don't want to give it to you, we'll do it from our own machinery, that is through vigilance department, will investigate, then CBI cannot force you to hand over that case to you. Now, rigor effect. One of our participants was asking. So now, if an employee is found guilty and penalty is imposed, then he will not get promotion. If major penalty has been imposed, so he will not get the promotion for 2 years from the date of passing of that order. Now, supposing 1st of June 2023, the order is passed for imposing a penalty. So till 2025. 31st May 2025, he will not get the promotion. Now, if a minor penalty has been imposed, then he will not get promotion till 31st of May 2024. That is 1 year, and major penalty 2 years. Now, censor. Now, supposing today he has been imposed a censor and tomorrow the promotion list is coming, he can be considered for promotion. But his case has not been decided. Now, tomorrow, supposing tomorrow the results are going to come, and still minor penalty case has not been decided, and it has been decided on 5th. And though he has been imposed with the censure, but he will not get the promotion. But before the declaration of the promotion, if he has been censured, the penalty has been imposed upon him to the extent of censure, then he can get the promotion. Now, password, we know password cannot be shared with anyone. Normally, what happens whenever I ask this question in any of my session, the people say password means passing of my word to the other employee, others word to. Likewise, they keep on passing their password. This is very wrong, and our rules are very strict in this regard. Now, if a password has been misused also by someone, so whose password has been misused, that person will be responsible for causing financial loss to the company or for any sort of a misconduct. Though we say that the password can be shared by taking an approval from your concerned officer, but normally what happens, he will also not give you a approval. And nowadays, password after 15 days or after a month, that you get a trigger from the system only that you need to change the password. So please ensure that passwords are not shared with any person. I've already explained it to you what is procedure for imposing minor penalty. First, there will be an investigation. See what happens, there is a complaint which says that something has gone wrong in one office. The investigating officer, means our vigilance officer, will go, he will investigate the matter. Then the investigation report will be placed before the disciplinary authority. He will decide, okay, we need, because this is not a misconduct which calls for a major penalty, minor penalty. So we will issue a charge sheet. Then written statement of defense will call. I have already told you minor penalty mein inquiry nahi hota hai. Then depending upon his written statement of defense or order of disciplinary authority, either to exonerate him or to impose a minor penalty. Same major penalty में भी है, investigation होता है, charge sheet होता है, written statement of defense होता है. Only thing is here there will be domestic inquiry by appointing IO and PO. That means oral evidence is a must here. Or you give an opportunity to the charge sheet and employee to explain his side orally before an independently appointed inquiry officer. Then inquiry officer by evaluating the evidences adduced during the course of the inquiry, that is oral and documentary, he will submit his inquiry report either declaring the employee as guilty or not guilty. Then depending upon that, the disciplinary authority will decide the quantum of punishment to be meted out to the disciplinary authority. Now, inquiry proceedings. जो departmental inquiry proceedings है. So there are two types of proceedings. One is judicial proceeding and the other one is quasi-judicial proceedings. What is judicial proceeding? Judicial proceedings means where there you find an judge is there, then prosecution advocate is there, then defending advocate is there. So that is a legally formed forum hota hai. That is judicial proceeding. And quasi-judicial proceeding means, see, now tomorrow if I am appointed as an inquiry officer, the moment that inquiry is over, I will no more be an inquiry officer. Whereas judicial proceedings are held before a judge who even after that particular case is where he remains to be a judge. So in inquiry proceedings and domestic inquiry, who is working as a judge? Our inquiry officer. Then who is public prosecutor? That is presenting officer. Who is accused? That is our charge sheet employee. And who is defending advocate? That is our defense assistant. Same way here, they are they are appointed by the government, and here we have been temporarily appointed as an inquiry officer, presenting officer. Now, rule number 39. See, sometimes what happens now, a person has been charge sheeted, inquiry has been completed, and the disciplinary authority has a grudge against that particular employee. And he imposes a very heavy penalty which is not incommensurate with the misconduct committed by him or the charges proved against him. Or it can be other way also. that disciplinary authority tries to favor him, though the charges are very serious, very grave in nature, but he is let off with a not that harsh penalty, which should have been commensurate with the nature of his misconduct, but imposes a penalty which is less compared to the penalty what was expected. So in that case, the appellate authority on his own can can call for the papers, and by application of his mind can either enhance the penalty or reduce the penalty or exonerate. In case of enhancement of penalty, he needs to give an opportunity to the employee that he wants to enhance this penalty, and therefore he needs to submit his representation as to why this enhanced penalty should not be imposed. Now, disciplinary authority's role. Once the inquiry officer submits his report, so saying that the charges are proved, so he can agree with the inquiry. He can agree with the inquiry. But supposing if the charge sheet, if the inquiry officer said that charges are not proved, and disciplinary authority is of the opinion that there was enough material or enough evidence against the employee, so he can disagree with the findings of the inquiry officer and find his and give his own findings based on the reasonings, which has to be communicated to the charge sheeted employee to enable him to make representation against the findings of the disciplinary authority. Or supposing if the disciplinary authority feels that the inquiry has not been conducted properly, or there was a vitiation of principle of natural justice, then definitely that inquiry can be freshly given to a newly appointed inquiry officer. Now you can ask me any query or any doubt, what you have. You can unmute your mics.
Sir, who is the authority to place an employee in suspension?
I've already told you, head of the department. Because that is not a penalty.
Okay.
Any question? पूछो जल्दी पूछो.
Sir,
Yeah.
Sir, can you explain the difference between minor penalty, that is withholding one or more increment temporarily, and a reduction to a lower stage not exceeding 3 years? What is the difference?
Yeah, I'll tell you. See, did you understand what is withholding of increment for a specified period?
Yes, that I understand.
Then you want to know the reduction in a basic salary for a specified period. See, withholding of tell me what is your query? What is the difference now?
Difference.
See here what will happen now. You just write down on a piece of paper.
Sir.
I will explain it to you. Withholding of increment for a specified period. We assume that it is 1 year only. So now supposing if his basic is 20,000 rupees and he is supposed to get increment into June, so his basic will remain 20,000, 20,000.
Yeah.
Okay. Now in June to 20, he will go to June 24. So what will be his increment? What will be his basic?
21,000. Withhold for 1 year. Suppose the increment is withholding for
now
1
see,
year.
we are in the month of May.
Yeah.
Okay. The penalty has been imposed of withholding us one increment for a period of 1 year. Okay. Now he is entitled to get June mein uska increment hai. So he will not get his increment. He will remain at 20,000 only.
Sir.
Now in June 24, 1 year of penalty is already over. So he is supposed to get his increment, that is 20,000, 21,000 rupees. Okay.
In the month of May of 2004.
June, he is supposed to get June. May.
Yeah.
तो अभी जून में उसका 1 साल complete हो गया. Okay. So he is entitled to get his regular increment, that is 21,000 plus one increment which has been withheld for a period of 1 year will be
Added.
will be restored. So he will be getting 22,000.
Right, sir.
This is withholding of
One or
for a
more income temporarily.
Now,
Yeah.
supposing his basic is May में उसका basic 20,000 rupees है. Okay, in June penalty of reduction by one stage temporarily for a period of 1 year. So it will be 19,000. Okay. Now next June when he goes, so it will be 20,000 plus 1. You understood or not?
Now, please explain that reduction to lower stage.
See, reduction by one stage, 19,000.
Acha.
That is for 1 year.
Sir.
Okay. Now we go to June. So that one increment will be restored. Sir. Plus one increment he will get by way of his regular
increment.
Yes.
Sir.
Okay. Understood?
Sir, yeah. Sir, got it.
Next. Next question.
Sir, if he in June he got penalty and reduced his increment by 2 slabs. And then
reduce it by 2 stages. Na?
2 stages, yes. And in December he in December his normal increment is there. Then
so he will get that increment, correct? Very good question. He will get his regular increment. So see, now he has come to 18,000 rupees. And you are saying December. So December he will get his regular increment. It will be 19,000. Correct. Then you come to June. So June he will be completing his 1 year of penalties period. So those 2 increment will be restored and he will be placed at 21.
Okay, sir. Understood.
Yeah.
Sir,
next.
Once again, explain reduction to a lower time scale.
Lower time scale means, see, whatever is your time scale. Say, supposing if it starts with 21,000 and ends with 50,000, assuming this person is at 48,000 rupees. So we reduce by 2 stages. So 2,000 rupees less means he will be placed at 46,000. Now he will go from 46 to 47, 48, 49, 50 after he completes 1 year.
Thank you, sir.
Hello.
Yes.
Sir, can you explain about the pension, that 4 years?
4 years. See, now I will tell you. See, supposing when a person is in service, see, he has joined in, say, supposing 2002, he joined in 2000. Or say he joined in 1990 and he is retiring 2020. Okay. Or 2023. Now, before his retirement, even 1 day before his retirement, if any misconduct is committed, so management can take a action against him. But assuming that he has retired and subsequently after 2 years, you come to know that he has committed a misconduct. So from that 2 years, you have to go back to 4 years. 4 years. You understood? And supposing within that 4 years that misconduct is committed, then only he'll be tried under our pension.
Meaning when they find out, that should be within 4 years.
Not find out. See, he has committed a misconduct. From that day till after his retirement, if 4 years are not over, then you can take action.
Okay. The day of committing.
See, I will tell you one thing. Now, a person retires on 31st of December 2023. Okay, we go supposing on 30th December 2019, he has committed a misconduct. He has retired on 31st of December 2013, and on 1st of January come to know this is a misconduct committed by him. So whether he will be tried under pension rule. He has retired on 31st of December 2013, and you have come to know about one misconduct committed by him on 1st of January, the next day of his retirement. But that misconduct he has committed on 30th of December 2019. So whether you can take action against him.
No, sir, no.
Correct. That means you have understood. You need to find out the day when he has committed a misconduct, and from that day you need to count for 4 years. Because here 31st December 2023, 4 years are already over. So you cannot take any action against him. I think most of the people must have understood this.
Thank you, sir.
Yeah. See, I have told you what is meaning of censure. Censure is a recorded warning, and for that you need to. A person needs to be issued a charge sheet. Unless and until the charge sheet is issued, you cannot impose a penalty of censure on that particular employee. So censure is nothing but a warning letter, recorded warning letter. For that, charge sheet is a must. And I have told you the effect of censure. Supposing if you have been imposed with a penalty of censure today and tomorrow the promotion are going to be declared, then you can be considered for promotion. For that, there is no regret. Any question?
So regarding deemed suspension,
Yeah.
is there a need to issue order as well?
Yes, yeah, definitely. See, unless and until you keep it in writing, how you will come to know that that person was placed under deemed suspension?
Okay, sir. Thank you.
Now, supposing if he has already been granted bail, but the period of his detention, that you know, from 1st of December to 30th of April, he was deemed to have been placed under suspension because you came to know how in the month of May or June. Any other question? Or we go forward? Should I go ahead?
Yes, sir.
Sir. Yes, sir.
Yes. Bolo. Any question?
In schedule, actually, if class 3, if from class 3 one person has been promoted to scale 1, sir. If he has imposed if disciplinary proceedings are in
you mean
process.
to say, supposing if a person has been promoted from class 3 to class 1 and the management wants to reduce his rank, it can be done. Because his original joining is in the cadre of class 3.
Yes, sir, but disciplinary proceeding will be applied to class 1 or class 3, sir.
Class 1. See, see, whenever you find the charge sheet, it will be mentioned in that the Mr. So-and-so, whilst working as administrative officer at so-and-so, in the year so-and-so, committed this misconduct. Now, even though if he is class 3, but now he is class 1, but he has committed a misconduct when he was in class 3. So you have to write down the Mr. So-and-so, whilst working as senior assistant during the year so-and-so at such and such places committed the following misconduct. But since he is class 1 now, so the disciplinary authority will be, which is applicable to class
1. Thank you, sir.
Yeah. Or okay, now we'll go to question answer session. Now you can given यांचे ते ऑन केलं तर चालेल कारण ते रिमूव्ह केलं तर प्रॉब्लेम. Now I am giving you some questions and options are there. So one by one you can read and give an answer. Not everyone at a time. Now find the odd one out in respect of misconduct of an employee. Taking or giving bribe or any illegal gratification. Acting in a manner prejudicial to the interest of the company, or honesty and hardworking employee.
3. Honest and hardworking employee.
Correct. Had that been a misconduct, then everybody, I mean, every one of us would have been charged. Now, charge proved against a suspended employee. What will be recoverable? 50% of what he was paid, 25% of what he was paid, entire subsistence allowance paid, or nothing is recovered. See, under suspension, we have said he is entitled to get 50%, then 75% or 25%. Now he has been proved guilty.
Nothing.
So nothing is correct. Now, assistant can be placed under suspension by head of the department, disciplinary authority, appointing authority, or all the above.
Head of the department.
Yes, but even a disciplinary authority wants to place him under suspension, he can also do it. Appointing authority can also do it.
All the above.
Nay, I'm telling you, head of the department is a correct answer. But all of the above can also, supposing if the disciplinary, that case is placed before the disciplinary authority and he wants to place him under suspension, he can do it. But ideally, it is the job of the head of the department. Now, appeal must be submitted within 1 month, 3 months, or 6 months.
3 months, sir.
3 months, sir.
3 months, correct. Now, which statement is incorrect? Department proceedings are quasi-judicial in nature. Disciplinary authority can decide the quantum of the punishment to charge officer. There is no need to provide full opportunity to charge officer to defend the case, or department inquiry has to be conducted within the ambit of the principle of natural justice. So, which is incorrect?
Option three.
So we see, I have already told you, whenever there is a charge sheet for major penalty, we must give an opportunity to the charge sheet employee to defend his case. Even in case of minor penalty, just because charge sheet has been issued without seeking his written statement of defense, you cannot impose the penalty. Which of the following is not a misconduct? Causing deliberate damage to company's property, absence from employee's appointed place of work without permission or sufficient cause, or commission of any act amounting to criminal offense involving moral turpitude, or absence from duty for 1 day without permission.
Absence from duty.
Option 4.
Absence from 1 day without.
No, absence from duty for 1 day. I have already told you, you cannot ask leave as a matter of fact, right? But only exception is that you can take 1 day CL without taking permission from your immediate boss. Which of the following is not a misconduct? Providing discount to client based on the claims experience, smoking in the office, neglect of work or negligence in performing duties, drunken or riotous behavior in the office premises or outside, gambling within the office premises.
First one.
First
Providing
one.
discount to client.
That is not a mistake. Correct. Which of the following statements are correct? Suspended employee can gainfully employ himself during the period of suspension. He can work in different office of the company. He cannot leave headquarters without permission of the office. Before releasing subsistence allowance, he is required to give declaration that during the period of suspension, he was not employed elsewhere. So before, in suspension, see, whenever you are releasing a subsistence allowance, so we need to take a declaration from the employee concerned that during the period of his suspension, he is not gainfully employed elsewhere. Now you give me what are the, whether these are the correct statements. Suspended employee can gainfully employ himself during the period of suspension, whether it is correct. Whether he can gainfully employ himself, say yes or no.
No.
He is suspended. Yeah, he can work in different office. No. He cannot leave headquarters without permission of the office. Yes. He has to take the permission. Then before releasing subsistence allowance, he is required to give declaration.
3 and 4, sir.
So both these two statements are correct. Now, disciplinary authority has to decide whether prima facie there is evidence to show misconduct on the part of the employee. whether the misconduct is of major or minor nature, whether there is a sufficient evidence to substantiate the charges, or all of them.
All of the above. 4.
Yeah, because see, once you get the investigation report, you will come to know whether he has committed a misconduct, and there are sufficient grounds to believe that that is the oral and documentary evidence. Then, depending upon the nature of misconduct committed by the delinquent employee, the disciplinary authority can decide whether to initiate major or minor penalty proceedings, and there is sufficient evidence. So, all of the above is the correct answer. Now, essence of the ideal inquiry proceedings do not include fair and impartial trial, assessment of evidence, timely completion of the inquiry, business procured by the charged officer.
4. Business procured by charged officer.
Because the management is not asking you whether you have procured this business or not, how much business you have procured, and just because you have procured a sizable business, that means you did not get a license to go to do any sort of a misconduct in the organization. Now, the penalty is decided by the disciplinary authority based on which of the following factors: degree of cooperation in the inquiry, past misconduct proved, sole or common misconduct, deterrent effect, and all of them.
All of them.
Huh? Correct. Then why we say degree of cooperation in the inquiry? See, normally what happens is you are appointing an inquiry officer and presenting officer. Those are also assigned with other duties. Now, he may be a divisional accountant, divisional manager, or a deputy manager, and presenting officer is also a divisional accountant, divisional manager. So they are required to spend that time for completion of this inquiry. But in a inquiry proceeding, if the charge-sheeted employees comes, he cooperates. And even if he is ready to sit after the office hour, that is, he wants to complete the inquiry as early possible. So that factor is also taken into consideration while imposing a penalty. Now, supposing during the course of the inquiry, he comes and admits the charges unconditionally. There also he has given us cooperation. So that factor will also be taken into consideration. Now, past misconduct rule. Now, earlier also he was charge sheeted and he was imposed with a penalty, but in spite of that, there is not an iota of improvement in his working habit. So definitely he will be awarded a severe penalty. Then sole or common misconduct. Sometimes what happens, people with the common intention of defrauding the company hatch a conspiracy and they do some misconduct. So such people are dealt with severe penalty. Then deterrent effect. What do you mean by deterrent effect? What do you mean by deterrent effect? See, what happens now? The penalty should be such that the other people should be also afraid. Yes, if we do this sort of a misconduct, now we are liable to be awarded with a severe penalty. So that will have a deterrent effect. Therefore, the answer is all of them. If charge official demands listed document submitting his reply, whether it should be given, should not be given at this stage, it depends on the discretion of the IO or it depends upon the discretion of PO.
1. It should be given.
It should be given. Who else? Who differs with this answer?
It should not be given.
See, as per our rules, what it is said now, once the charge sheet has been issued, the delinquent employee is supposed to just say whether he admits the charges or denies the charges. Actually, as per rule, if you go to court now, then as per rule, the listed document needs to be given to our charge sheeted employee. But as per our CDA rules, it is said that it should not be given at this stage. At the time of preliminary hearing, it could be given. Now, which authority is competent to review an order issued by disciplinary authority, even if no appeal is made against the said order? We have just discussed about that rule number 39. So, who should be this one?
4. The appellate authority.
Appellate authority.
Appellate authority. Now, who is not provided? What is not provided in CDA rules of the company? Appointment of inquiry officer, appeal to appellate authority, memorial to general manager, and memorial to CMD. Yeah,
Memorial
correct.
to general
Memorial to
Third,
CMD is not there. See,
Memorial to general manager.
yeah, memorial to general manager. Correct. Memorial to general manager. Sorry. See, appointment of inquiry officer is there. Then you can make an appeal before the appellate authority, that is given in this CDA rule. You can prefer us memorial to CMD up to the scale of scale 3 officer. But memorial to general manager is not there. The general manager is at the most appellate authority and the disciplinary authority. Okay. Now, general insurance CDA rules were framed in the year 75, 73, 76, 78.
75, 1975.
97. An employee is deemed to have abandoned his post if he remains absent unauthorizedly for a period of 30, 60,
90 days.
90 days.
90 days.
90 days, correct. Now, employee under suspension is entitled for living alone, dearness allowance, subsistence allowance, or family allowance.
Subsistence allowance.
Subsistence allowance, correct. Now, CBC guidelines stipulate bids for acquiring office premises on lease purchase as acquired. Technical bid, financial bid, preliminary scrutiny, or both one and two.
Four.
Huh? So, what is technical bid and financial bid? I will just explain it to you because I thought that by way of this question only I will be able to explain it to you. See, whenever, supposing tomorrow if I want to construct a building, so and I want to hire someone, so what I will see into him, आपका घर बनाना है, बिल्डिंग बनाना है, तो आप एक वेल्डर को जाके बोलोगे घर बनाना है. You will approach whom? You will approach a civil engineer. You will approach a civil engineer. Now, after approaching civil engineer, if he tells you that this much is the cost, and he say 30 lakhs rupees is there. So what you will say? I am going to give you 30 lakhs rupees right now. You will never say. You will say, okay, after you complete your work, 10% of the work, 20% of the work, I'll give you. So before and whenever you call for a bid, so first you need to call these bids in two ways. First is technical bid. Why we call financial bid and technical bid? Both bids will call. And what we will do first, which bid will open? पहला bid कौन सा open करेगा? Technical या financial? Technical. Because we need to find out whether he is technically sound to carry out that particular one or not. So once that technical, supposing there are 10 bids given under technical bids, out of that 4 are disqualified and only 6 are eligible. Now out of that, how many financial bids you are going to open? See, we have got 10 technical bids. Out of that, 4 have been declared as invalid.
4, sir. 4.
Now 6 are remaining. So we'll be opening the financial bid of only people those who are qualified in technical. So answer is 1 and 2. Now CDA rules are not applicable to class 1 officer, class 3 and 4 employees, class 1 officer on deputation from government sector and PTS.
3.
Answer is 3.
Why they are not? Why these rules are not applicable to them? Because they will be.
They have their own
parent company.
They are coming.
Yes, correct. Now, Chief Technical Examiner's organization function under the administrative control of. Now, what is Chief Technical Examiner? I will tell you. You know our head office. Our head office में वो अपना buildings किधर है वो बड़ा?
Port.
That is our head office building, but we have got some flats at Malabar Hill. So whenever some renovation work is taking place now, so it runs in lakhs and crores of rupees. So whenever this work is being conducted, is being undertaken by us, so as per CBC guidelines, the Chief Technical Examiner's organization will come to inspect that. So what they will inspect, whether we have called for the bids properly, whether advertisement were given, whether broader publicity was given, whether work is being done according to the contract what we have entered into, whether the material supplied is correct, whether the payment has been made in commensurate with the percentage of work, whether amount has been kept in reserve to look correct the defects in future. So they will come and they will look into this particular work what has been going on. So that CTE, that is Chief Technical Examiners Organization, works under the auspices of CVC, Central Vigilance Commission. Now, common proceedings. 2 or more employees are permission for 2 or more are permissible under rule
29.
अपन ने बात किए थे अभी, that is 29. Now CVC stands for what? Central Vigilance Commissioner, Central Vigilance Commissioner, so Chief Vigilance Commissioner, Central Vigilance Commission, or Chief Vigilance Commission.
3.
Central Vigilance Commission.
Central Vigilance Commission. Now, dismissal order can be issued by officer in charge, competent authority for imposing major penalty, appellate authority, or appointing authority.
Appointing authority.
Appointing authority.
So, no, even if the disciplinary authority is say of a much lower rank, but if the appointing authority is of a higher rank, then the order of removal, dismissal, or compulsory retirement, that will be passed by only appointing authority. Subsistence allowance can be increased to 75% after 3 months, 6 months, 9 months, or never.
6 months.
6 months.
6 months. And
6
when?
months.
Under what circumstances?
If the employee is
Not by the employee.
Employee is cooperating.
corporate.
Now, during the pendency of inquiry proceeding, if an employee is found suitable for promotion, then consideration of promotion is deferred, rejected, or kept in an sealed envelope.
Kept in sealed envelope.
Sealed envelope.
So, do you know what is sealed envelope? See,
Suna
an
hai.
inquiry, a case is going against an employee. So, whether you know whether he is going to be found guilty or not guilty, you don't know. But he is due for promotion. So, that time what will happen now? His name will be considered, I mean, from all parameters. Uska CR, service record, technical qualification, everything, and the merit list will be prepared in descending order. Okay, the topmost will be on top, then 99, 98, 97, like that. And supposing if this person, by virtue of his all traits, uska seniority, interview, then technical qualification, and he is placed at the 5th in the rank, because he is supposed to get the promotion. But since he is his case is going on and we don't know what will the fate of his case, so his promotion will be kept under sealed by the promoting authority. It will be not known. So when the result will be declared, and by that time, supposing his result is not over, or his findings of the inquiries are not known, and the decision of the disciplinary authority is not taken, then his name will be kept under sealed envelope. And tomorrow, supposing after 6 months, if no charges are proved against him, then his envelope will be opened, and he will be seen at what rank he has been placed. Since he has been placed at rank number 5 and there were 30 vacancies, which we have already filled, because we don't wait for 6 months. So what will the fate of this person? Actually, he should have got the promotion. And who is at fault in not completing the inquiry? Management. So that time his name will be considered for promotion under sealed envelope, and he will be declared to have been promoted from the date on which the results were declared, or on the date on which the other people have taken the charge. So his seniority will be maintained per se. Then, though his promotion will be effected from the date of his joining, but his seniority will be from the day on which the other people have taken. Supposing the common date of taking charge was declared as 30th of June, and he is getting promotion on 30th of December. So on 30th of June, he will get the promotion, and notional increment will be given to him, but it will not be given, it will not be released to him till he actually takes charge in the promoted cadre. So he has taken charge from 30th of December. So for 30th of December, he will not be given any financial benefit, but on 30th of December, when he takes actual charge from there, his salary will increase.
If there are only 30
So supposing if there are 30 vacancies and this is the 31st person, but still you need to promote him and that vacancy will be not adjusted against future vacancies.
And that 30% will not be.
No. So those 30%, those who have been already promoted, they have already been promoted, they have taken charge. And this person will be 36 to get the promotion, though he was appearing 5th in the merit. Only thing is that he will be given a notional salary fitment from the date on the promotion on which the promotions were declared. But that effect, actual effect, he will get from the date of taking of the charge in the promoted cadre. How much time? किती periods एक जोपर्यंत त्याचा येत for one promotion exercise. After the next month परत त्याला घेतात. He has to appear again. On noticing misconduct, what is the recourse available to disciplinary authority? Exoneration to start disciplinary proceeding or no action? Somebody has committed a misconduct and that is placed before the disciplinary authority. So whether he can exonerate him or whether he can start a disciplinary proceeding or he will not take it.
To start
a disciplinary proceeding.
Correct. And he needs, we need to take start a disciplinary action only, then only we'll come to know whether he's at fault or not. Now identify which of the following does not attract vigilance angle: unusual delay in taking decision, reckless decision attributing to the financial loss of the company, possession of disproportionate asset, or failure to submit annual property
Second.
Reckless decision, that will be a vigilance angle.
Fourth also.
Unusual delay.
No, sir, madam.
Four,
Unusual
sir.
delay. I just want to explain. Unusual delay in taking decisions. What has happened? One claim has been processed, settled. Recommended, settled also, but the payment has not been released. And in between, there is a complaint from the claimant stating that my claim, though I have submitted my paper, it's more than 3 months. I am not getting my claim settled or the amount which I am supposed to get, because the concerned person is asking some sort of a gratification from. Then it becomes a vigilance act. So therefore, whenever we have been given tag for settlement of the claim, so we need to follow that track. So you should not give any chance to any claimant to make even a false complaint against. But if the paper shows that the claim was already settled 2 months back and the payment has not been released to him, then definitely you are taking unusual delay in taking. Now here the answer is failure to submit annual property return. See, we have been given 30 days time after 30th of March to 31st of March to submit your property return by 30th of April. Now, supposing even if you don't submit it, it will not attract a vigilance angle, because whenever you will submit, you will have to give the account of the property purchased and sold during that particular period, because that financial year has already ended and those transaction what has taken place is already recorded. Only thing, by way of property return, you have not submitted it, so that is not that will not involve a vigilance angle. Now, if pension opt is terminated by way of a major penalty, which of the following is not payable to him? Fraudulent is payable to him because that is his own contribution.
Gratuity, sir.
Gratuity, sir. Four.
Gratuity and pension will not be paid.
Both pension and gratuity.
Both. See, pension is no, pension is not payable. Now, which of the following misconduct? See, here you will find that pension has been written. See, sometimes what happens now, actually pension also they are stopping, but pension has been started with the social object in mind now. So the family members of the pensioner should not suffer. So therefore, supposing tomorrow if he makes a representation, I mean their family member makes a representation before the our pension sale, then management can decide upon to release him some sort of a pension on compassionate ground. But gratuity will not be payable.
Sir,
Even
compensate pension will be payable in this case. No?
yes, compensate payable will be payable provided the management agrees for it.
Yes, not more than 2/3.
Yeah, correct. Now gratuity is not payable.
Sir, one more question with the compassionate pension.
हाँ.
सर वो लोगों का क्या वो जो होता है डीए इंक्रीमेंट होता है 6 महीने में जिसको बोलते हैं जो
वो सबको होता है, तो सबको होता है।
वो कॉम्पनसेट वाला को भी डीए मिलेगा?
हाँ, सबको मिलता है, मिलता है।
अच्छा।
Now, which of the following misconduct would not attract vigilance anger? ये हो गया है अपना, सेम है वो। अच्छा, who can act as defense assistant in an inquiry proceedings? Only assistant, only senior assistant, employees or retired employees?
Employees.
Only employees.
Employees.
They can be assistant, they can be senior assistant, they can be manager, they can be RM, DGM, GM, CMD. They are employees of the organization. What will the fate of the inquiry proceeding if the employee dies after issue of charge sheet? Yeah, this is the question because here no option is given. So after the issue of the charge sheet, if the employee dies, so what will the fate of the inquiry?
Cease.
The inquiry will come to an end. Now, supposing if the inquiry has been completed and he dies, what will the fate of the inquiry?
No action, sir.
No action, sir. No action.
After submission of inquiry report has been submitted and he has been declared as guilty.
So no action, sir.
No action, sir. No action.
Now, after passing of office order, but before it's received by him, see, management had decided to terminate its services, and before that order was acknowledged by him, he expired. So, what action?
No action, sir.
No action, correct. So, the inquiry proceeding comes to an end only after the office order has been acknowledged by the delinquent employee. Understood?
Yes, sir.
Yes, sir.
From their legal lawyer.
Other disciplinary proceeding can be initiated against retired employees under pension if the misconduct is committed within
4 years.
4 years of its occurrence.
Occurrence of
occurrence of the
misconduct.
अच्छा, बच्चे लोग भी सुन रहे हैं क्या? अभी से तैयारी कर रहे हैं।
तैयारी कर रहे हैं फ्यूचर नेक्स्ट पीढ़ी।
चलो, अच्छा है। Major penalty can be imposed on an employee against whom major penalty charge sheet issued. Correct or wrong?
Major penalty.
Correct.
Then minor penalty can be imposed on an employee against whom minor charge sheet is issued.
Correct.
Minor penalty can be imposed on an employee against whom major penalty charge sheet is issued.
Yes, correct.
See, major penalty charge sheet issue kiya, but after the fate of the inquiry was known, the management is of the opinion that the charges against proved him are not that serious. Therefore, they want to impose a minor penalty. But if a minor penalty charge sheet has been issued, whether you can impose a major penalty?
No.
Why? Because you are not giving an opportunity to charge sheet employee to present his case before an independently appointed inquiry officer. The authority for forfeiture of gratuity lies with
CMD. Disciplinary authority.
No, CMD. Disciplinary authority is sitting at RO level, DO level. How they can forfeit the gratuity?
Yes,
Now, standard of proof required in a department inquiry is that of proof beyond reasonable doubt and preponderance of probabilities, and it depends upon the discretion of the inquiry officer.
One proof beyond reasonable doubt.
No, that is correct. What answer you have given, I'll just explain it to you. Now, proof beyond reasonable doubt is required in criminal proceedings.
Sir, third, it's depend upon the discretion of inquiry officer.
Discretion of the, how can he uses his discretion? Supposing if he's got a, I mean, that person is his favorite, so we'll just ask him, I mean, exonerate him. It's not like that. See, there is a difference between the inquiry, the criminal proceedings and disciplinary proceedings. So in criminal proceeding, what happens now? Supposing tomorrow, if we किसी को charge किया है, कि Mr. X has murdered Y. So this is a charge, but for proving that, you will have to prove that who was that person who has murdered him. The guy said what was the weapon used, what metal it was, from which hand he stabbed, from which side of his body he stabbed, whether any person was there, whether there was darkness or light, enough light was there to see, which side of the road he was murdered, whether n number of questions are there, and all these questions are to be ticked. Then only it will be proved that he is the person who is the main culprit and he will be declared as guilty. But in department inquiry, we say preponderance of probabilities. What is preponderance of probabilities? I'll give you an example. Earlier we used to use cover notes. Now I have given one cover note book to one development officer, which contains 25 cover notes. What has happened in between one cover note, 1 to 25, say, assuming the number 17 cover note has been produced before the court, wherein the vehicle is shown to have been insured against liability policy, and there was a third party claim on it. And what has happened that that cover note has been produced in the court. So on that basis, court will declare. I mean, court will give the award in favor of the claimant against the company. Now, when we approach our development officer, he says that this cover note is not my signature, and I don't know who has used this. So whether we should let him off like that only?
No.
Why?
Because he has received the cover note, and cover note should be with him and with.
See, the responsibility of keeping safe custody of the cover note lies with him. Secondly, supposing if that those were the pre-signed cover notes, then also it was his responsibility. Even if it is stolen, so he should have informed the office well in advance, not afterward when the claim has been reported. So all this leads you to make believe that he is responsible for causing financial loss to the company. Correct? So the standard of proof required in a department inquiry is that of preponderance of probabilities. That is, there is, to prove the charges against him is the most probable cause of causing financial loss to the company is issuance of that cover note, which has been given to our developer. You understood?
Okay, sir.
Yes, sir.
Yes, sir.
Now, terminal dues which cannot be attached even by an order of the court is
GSLI.
Leave encashment.
I've already told you.
Leave encashment.
BF. Read the question properly. The terminal dues which cannot be attached by even an order of court is PF. PF and GSLI. One part of the GSLI goes to is a sort of your savings, your own savings. Am I right? You must be paying this GSLI, na? That deduction is being made from your salary or not, or it's an optional thing.
No. It is deduct from our salary.
Yeah. So one part is your for life insurance and one part is your savings. So the part which is being saved that cannot be attached by the.
So which one is the answer, sir? PF is the answer.
PF and part of GSLI. So here, normally you will find this question which is coming to in examination. There only you need to answer PF.
Okay.
Now, under Prevention of Corruption Act, a government servant can be prosecuted for wrongful gain, misappropriation, wrongful loss to the company, all of the above.
All of
All of the above.
All of you.
What procedure is followed in acquiring office premises as per CVC guidelines? Advertisement newspaper, placing the advertisement in company's website, putting the advertisement on notice board of the company, all of them.
All of
All of
the above.
Because you are giving wider publicity. Which is correct sequence as per CDA rules? First investigation, then charge sheet, then domestic inquiry, then office order. Or investigation, domestic inquiry, charge sheet and order, or domestic inquiry, charge sheet, investigation and order.
First one, sir.
First,
Who,
correct.
sir?
First will do investigation. Based on that, charge sheet will be issued. Based on that, inquiry will be conducted, and depending upon the outcome of the inquiry, the necessary order. See, this order means not penalty. This can be exoneration also.
This was a question in the last year exam, 2 to 3.
Acha. As per CDA rules, who can be appointed as inquiry officer? Public servant, only central government officer, officer of the company, or retired officer?
Officer of
Officer of the company.
Officers of the company also. These is two answers.
Retired officer of the company also.
A retired officer of the company. Public servant, that's a generalized term given. Public servant can be an assistant also, but we don't appoint any clerical cadre or person as an inquiry. And only central government officer. No, central government officer we can appoint, but not only. So officers of the company, retired officers of the company, central government officers, but not only. Which of the following is not a major penalty? Termination of services, withholding of increment permanently, withholding of increment for 2 years, compulsory retirement.
Withholding of increment
for 2 years.
Whenever such questions come, and if you are unable to answer, just think that any penalty which has got the permanent effect will be major penalty. Any penalty which has got a temporary effect will be minor penalty. So here, major penalty, withholding of increment for 2 years, it's not a permanent effect, it's a temporary effect. So this is a minor penalty. Now, who can act as defense assistant? Employee of the company, retired employee of the company, legal practitioner, employees of other general insurance company.
First one, sir. Employee.
Employee of the company.
Correct. Now, section 16A deals with annual employee report, annual premium statement, annual cost, annual property return, annual claim statement.
Annual property returns.
Correct. Which is the correct sequence? First order of appellate authority, then order of disciplinary authority. First order of disciplinary authority, then appellate authority, and then memorial. First memorial and then appeal.
Second, sir. First order of disciplinary authority.
First is session court, then the other one is high court, and third is Supreme Court. That is disciplinary authority, appellate authority, and memorial. If a person has been detained in police custody exceeding 48 hours, he is deemed to have been suspended from the services. If no bail is granted to him, he could not get bail due to intervening holidays.
First one, sir.
First one, sir.
No bail is granted.
Correct. Now, suspension can be revoked by disciplinary authority, appellate authority, CMD, the authority who has placed the said employee under suspension.
Fourth one, sir. Fourth one.
See, who can place a person under suspension? Head of the office. So the person who has placed him under suspension is entitled to revoke his suspension. He's got the authority to revoke his suspension.
Sir,
Yeah. Puche. Hello.
Fourth is the answer, sir.
Fourth is the answer. Yes, sir. And inquiry should be ideally completed within a period of 3 months, 9 months, 1 year, or 6 months.
6 months.
3 months.
Actually, 6 months they say, but yeah. No. Actually, our CVC guidelines says that it should be completed within a period of 6 months, whereas CVC says that it should be 3 months. But the answer is correct answer is 6 months. The appellate authority can enhance the penalty, reduce the penalty, exonerate the employer, all of these.
All of the
All of the above.
And he can also reject his appeal. Correct? And one more option can be reject his appeal also. So supposing if he feels that the penalty is not commensurate with the misconduct, then he can enhance it. If he feels that the penalty is disproportionate to the misconduct, then he can reduce it. And if he feels that this person is not entirely responsible for this misconduct, so he can exonerate. So all of the above. Which of the following action won't be called a misconduct? Taking or giving bribes, submission of false LTS, being given oral or written statement in press without the permission of the office, sleeping while on duty, and occasional late attendance.
Occasional
Fifth one.
Fifth one, not fourth one, na?
Fifth one.
No, sir.
No.
Occasional letter.
Yeah, I hope you all are awake only.
Occasional late attendance.
वो बच्चा खाली सो रहा है, देखो उसने सुन लिया मेरा. An employee can be placed under suspension except in case of action is contemplated against him. He is detained in the police custody for more than 48 hours. Criminal case is pending against him, or unauthorized absence.
Unauthorized absence.
Fourth one.
Why? Unauthorized absence is also a serious misconduct. Why he should not be placed under suspension? This is for your knowledge. See, if you place a person who is unauthorizedly absent under suspension, he will start getting the suspension subsistence allowance.
It's the misconduct, na CDA process.
But see, the thing is that why we don't place such person under suspension, because he is unauthorizedly absent. Anyway, he is not getting salary. And supposing if you place him under suspension, you start getting the subsistence allowance. So in unauthorized absence case, we don't place an employee under suspension. Otherwise, सब लोग वैसा ही करेंगे. Unauthorized absence रहेंगे, 50% ले लो, बस कर. Whether a suspended employee can engage himself in gainful employment, work in different offices, be present in the office and do work, he should not be allowed to do work in any of the office. Whether he can engage himself, these are not, I'm just asking you, whether a suspended employee can engage himself in gainful employment, no. Whether he can work in different offices, no. Whether he can present in his own office and do work, no. He should not be allowed to do work in any of the offices. Yes.
Sir, my question is here. कोई भी एम्प्लॉय अगर सस्पेंड हो रहा है तो इट्स मस्ट कि ही इज डेली कम टू ऑफिस.
No, definitely not. He is not supposed to enter the office premises.
Okay, it's a,
see, at the end of the month, when we release him subsistence allowance, we need to take a letter taking his confirmation that during this period he was not gainfully employed anywhere else.
Means आप घर रहो और 50%
बस रहो. Yes.
Sir, in one case, if employee is on his 50% substance allowance is not enough for his emoluments, in that case, if the employee already took permission from the appointing disciplinary authority, that he will work at he'll keep a shop like that.
No, he cannot do anything. Anyway, he is an employee of the organization. And during the period of suspension, he is not supposed to gainfully employ himself anywhere else. Okay. Now, which of the following is true? Disciplinary authority must give copy of the inquiry report to the employee. Not necessary to give copy of the report. Should give copy only if the employee demands. Under no circumstances, it should be given to employees as it is a confidential. Which one is the correct? See, I will tell you once the inquiry is over. So as per statute, the charge sheet employee need to know whether the charges against him are proved or not. So he will come to know only if the inquiry report is given to him, and he will be able to analyze whether the charges proved against him are based on the oral and documentary evidence adduced during the course of the inquiry, or the inquiry officer on his own has drawn the conclusion. So therefore, giving an inquiry report before imposition of the penalty to the employee is a must. If two vigilance cases are going against one employee, how many penalties can be imposed upon him? Not more than one penalty, any number of penalties, separate penalties for two separate cases, none of the above.
So separate penalty for two separate.
Correct. Because you have issued him two charge sheets, independent inquiry officers are involved, two independent inquiry reports are there. So the penalties needs to be separate. Which of the following statement is true? Disciplinary authority himself can conduct inquiry as inquiry officer. Inquiry can be conducted by the duly appointed inquiry officer. Statement 1 is correct. Statement 2 is correct. Both statements are incorrect and both these statements are correct.
Sir, both are correct.
Correct. Because see, disciplinary authority, whenever he appoints an inquiry officer, so he delegates his authority to a newly appointed inquiry. That means he also can conduct, but because of the various constraints like office work, office exigencies, he cannot spare himself to work as a disciplinary authority. He assigns his work to the other person as an inquiry officer. So both the statements are correct. What happens if the employee suddenly admits the charges during the course of the inquiry? Inquiry needs to be completed. Inquiry comes to an end. Inquiry will be temporarily suspended till the advice of Vigilance Department received. IO to seek advices of disciplinary.
Inquiry need to be completed.
Needs to be done. See, he has already admitted, madam, what you are going to do subsequently. If I am charge sheeted that I have misappropriated a premium of 10,000 rupees, which I admitted. So where is the question of completing the inquiry? I have already given my admission. That is, but whenever you are taking the admission, it should be unconditional, without any pressure or under any duress. So inquiry comes to an end. There is no need to complete it. There is no need to send it to Vigilance Department seeking their further advice or seeking the advice of the disciplinary authority. Now, reference is made to CVC before initiating disciplinary action against Senior Assistant Development Officer, officer up to the scale 4, and then officer of scale 5 and above.
Scale 5 and above.
So what we
Five and
say,
above.
yes, scale 5 and above. Appellate authority can enhance the penalty, reduce the penalty, exonerate the employee. All this. In domestic inquiry, which of the following is not correct? He cannot defend his own case. He can be assisted by a defense assistant from same region. He may engage a legal practitioner. He can engage an employee from other RO as his defense assistant.
He may engage
He cannot, whether he can defend himself. Yes, he can defend himself. He can be assisted by defense assistant from the same region. Yes,
sir.
Whether he can engage a legal practitioner.
No, sir.
Whether he can engage an employee from other RO.
Yes,
sir.
Yes, sir.
Firstly, no, sir, but in any like
See, as per rules,
to management
as per rules, he cannot engage. He cannot engage an employee from other RO because RO will not give permission. But if he is ready to come on his own by bearing his own expenses, then it can be allowed as a special case. But as per rule, he is not allowed.
You appointed a legal practitioner.
Sir, then what is the correct answer? Sir, what is the correct answer?
Huh?
So what is the correct answer?
These I have given you these examples, so which are correct and which is not correct, that I wanted to explain. See, he can defend himself. He can assisted by the defense assistant. He may not. He is not allowed to engage a legal practitioner, and he can engage an employee from other RO as his defense assistant, provided it is approved by the competent authority. Now, role of CDI. What is meant by CDI? CDI means Commissioner for Departmental Inquiry. It's written there. Likewise, see, supposing if there is a case of a regional manager or deputy general manager or general manager, and we appoint any employee from our organization, that in the higher cadre. Now, DGM's inquiry is being conducted by general manager. General managers is conducted by CMD. So what you feel, whether the justice will be there? See, normally if you find, I don't know in what cadres you people are there, but you will find there are n number of cases against the officers in the cadre of class 1, 2, 3, 4. But you will find very rare cases for regional manager, deputy general manager, and CMD. Therefore, if a case against RM and above cadre is registered, then CVC on their own, they have got one department that is called Department for, they have one commissioner for departmental inquiry. So he will be appointed as an inquiry officer because they want to ensure that the inquiry is conducted in a fair manner. There is no, no partiality is there. So a person who comes from Central Vigilance Commission, he doesn't have to do anything with our RM, DGM, GM. He will submit his report on the basis on the merit of the case or whatever evidence has been placed. So this is CDI. CDI means Departmental of Commissioner for Departmental Inquiry, work under the auspices of Central Vigilance Commission. You understood this?
Yes, sir.
Yeah. Was. If you have got any question, still some question if you have got in your mind, you can ask because we have come to an end of the session.
Hello.
Bolo sir.
Sir, explain once again deterrent effect and preponderance of probabilities.
Deterrent effect. See, deterrent effect means, supposing if a person has misappropriated a premium of, say, 5 lakhs rupees. And you, as a disciplinary authority, you want to impose a penalty which will be a deterrent to others. So, what penalty you will suggest? Now, supposing I want to, reduce his basic salary by 1 stage, whether that is fair enough? He's already earned 5 lakhs rupees, and you want to continue that person in the organization. That will be a. That will give a bad example to others. They will say, even if we misappropriate a premium of 5 lakhs rupees,
okay,
so we are going to be let off with a penalty of 1 increment. But if you dismiss, so the other people will have that fear. They will not venture to misappropriate the.
Correct.
So that is called deterrent effect.
Correct.
You are from Delhi or what?
I am from Ludhiana, Punjab.
Anil Gupta.
Yes.
Okay. Who is vigilance officer at Ludhiana now?
Now, Mr. Rajiv Agarwal is Chief Regional Manager there. Here.
Vigilance officer.
Vigilance officer is Mr. Virender Kumar.
Virender Kumar.
Mr. Virender Kumar is vigilance officer here now. In Ludhiana.
Mr. Gurinder, Mr.
Long back, Mr. Gurinder was here.
Correct.
Mr. Gurinder Singh was here as vigilance officer. No, he was not in vigilance in Ludhiana.
But somewhere he was there. But I met him at Ludhiana only when I had come there.
He was working with
IDD. He was in IDD.
He was in
personnel department.
He was in personnel department. Okay. Then he was in vigilance in Chandigarh.
Chandigarh, correct.
Yes.
वो अच्छा है चंडीगढ़ और लुधियाना उधर से स्वैप करते रहते हैं.
हाँ बिल्कुल पास पे है चंडीगढ़ लुधियाना पास है.
अच्छा, now you are asking about
my one query is preponderance of probabilities.
Preponderance of probabilities. मैं आपको एक लाइटर इसमें आपको एक बताता हूँ.
जी सर.
अभी आपने बचपन में एक किस्सा सुना होगा ऐसा. यानी एक शिकारी ऐसा अपने हाथ में राइफल लेके जाता है ऐसा. और वो देखता है दरख्त पे ना 5-6 कबूतर बैठे होते हैं. हिंदी समझ रहा है क्या बाकी के लोगों को?
मैं हिंदी भाषी हूँ. मैं हिंदी
नहीं दूसरे लोगों को भी मैं.
हेलो.
तो शिकारी क्या करता है, अपनी बंदूक निकालता है, ऊपर 5 कबूतर बैठे होते हैं.
Explain in English, sir.
Yeah. See, one hunter he was walking on the road with the pistol in his hand. So he saw some pigeon sitting on the tree. So out of his anxiety, he takes out his pistol and he shoots one pigeon. वो pigeon गिर के नीचे उसको यानी pigeon को shot करता है, then pigeon falls on the road. So my question is, how many pigeons are there on the tree?
Oh, nothing.
Nothing. But I'm challenging you. Your answer is wrong. Your answer is wrong. I say one pigeon was there.
That dead one.
Not dead one. Oh, hardly any. Sitting on the tree, the branches of tree. One pigeon was still sitting.
Hearing gun sound, all maybe fled away.
So he was, that pigeon was deaf. तो ऐसा ही preponderance of probabilities है. Preponderance of probabilities means though you don't have a direct proof, but there are circumstantial evidences which proves that this person is responsible for commission of this particular mistake. I have already given you an example of issue of a cover note. That cover note has been misused, and that cover note book was handed over to say XYZ, which was containing 25 cover note. Out of that, cover note number 17 has been misused, and this fellow kept mum on this. Subsequently, when the cover note came to the management or the office through MSCT case, that time only we could know that this cover note has been issued for covering a particular vehicle which met with an accident, for which the premium has not been deposited with the company. So now, who should be held responsible? That has not been issued by him. We understand that.
Okay.
Even the premium has not been issued by him. But what circumstances tell you rather?
Correct.
See, the cover note book was with him, 1 to 25. He was supposed to ensure safe custody of it. He was supposed to ensure that all the cover notes are issued in serial order. He was supposed to ensure that the premium against the respective cover note is deposited in the office. He was supposed to see whether the cover note number 17 has been issued by him or not. If not, then he should have brought it to the notice of the management immediately. But he has kept mum. And after 1 year, when the claim was reported, and when he was questioned, that time he is saying this cover note was stolen. So who should be held responsible? Anil ji.
जी sir.
Who should be held responsible? कवर नोट बुक किसको दिया है भाई? मैं बोलता हूँ आपका चेकबुक है, आपका चेकबुक है, आपने चेक प्री साइन करके रखा हुआ है. वो एक चेक उसमें से मैं निकाल के लेके पैसा विड्रॉ करके ले लेता हूँ. पैसा विड्रॉ करके लेता हूँ. गलती किसकी है इसमें? कल तो आप बोल नहीं सकते मैंने चेक आपको दिया नहीं, बिकॉज इट इज अ प्री साइंड.
यस.
तो गलती तो आपकी है ना. तो ऐसा ही इसमें डेवलपमेंट ऑफिसर की गलती है. तो इसके लिए the circumstantial evidences are speaking against the person to whom the cover note book was issued. So that is called preponderance of probability.
Correct sir. बिल्कुल. अब नहीं.
और
preponderance of probability कई बार इसमें जो आदमी जो वो नहीं है, जिसका कसूर नहीं भी है, शायद इस रूल में उसको लिया जा सकता है.
नहीं लिया जा सकता है, ऐसा नहीं है, ऐसा नहीं. मैं उसीलिए तो आपको बोल रहा हूँ ना. There are very few cases where this rule will be applicable.
Okay.
लेकिन कैसा है कि हमारे यहाँ भी हम देखते हैं कि there should be sufficient evidence, concrete evidence against any employee against whom the departmental action has been initiated, either by way of documentary evidence or oral evidence.
Correct.
देखिए सर, मैं आपको बताता हूँ. मुझे तो रिटायर हो गया, काफी वक्त हो गया, लेकिन we could save n number of people. I can give example of Ludhiana, I can give example of Delhi, I can give example of Chandigarh, or all over India. That's not a problem. N number of people were exonerated. Even from CVC also we could exonerate them. ऐसा नहीं है कि यानी जस्ट विजिलेंस डिपार्टमेंट है, जैसा हम बोलते हैं ना, एक हिंदी में कहावत है, बहुत अच्छा और बदनाम बुरा. विजिलेंस डिपार्टमेंट का नाम ऐसा ही खराब करते हैं लोग. जो लोग करते हैं, मिस्टेक करते हैं, तो दे शुड बी डेल्ट विद प्रॉपर्ली ना.
करेक्ट. हाँ, वही बात है. मैं वही दिस इज द करेक्ट. यस, दिस इज द थिंग. मैं उसको प्रॉपर्ली.
एनी अदर क्वेश्चन
सर?
yes.
What is the period of normal place of posting? It's a 5 year or 7 year? It's a
5. NPP 5.
Somewhere is written is 5 year or
NPP 5 years.
5 years. Normal place of
NPP 5.
posting.
Yes.
Hello, sir. One more question. Can I ask, sir? Hello.
Definitely, I am sitting here. I am waiting for your question.
A contractual employee steals a computer. The action to be initiated by management. This question last year, sir.
See, you can lodge an FIR against him because he cannot be tried under your CDA rules because he is not. He doesn't come under the ambit of CDA rules.
So FIR. Sir, and one more question, sir.
Yeah.
Women harassment at workplace. How CDA deals with that?
How CDA deals? I have already told you. Supposing if there is a complaint against the particular employee by that lady employee, that will be dealt with properly. I have told you people have been dismissed from the services, not assistant and even manager cadre people have been removed from the office.
Excuse me?
Yeah.
Sir, what's the effect of misconduct before retirement? Just please explain it again, sir.
Before retirement means?
Yes.
No, I'm not getting you. What you are trying to ask?
4 years are left before that you have explained it, no?
Yeah, correct. Now, supposing if a person has already retired and that commission of misconduct has taken place 4 years back, so he will not be under that rule, rule number 43. He cannot be tried under that. For 4 years. Before 4 years, definitely. Supposing 4 years is not completed from the date of the cause of that action, he can be tried. Kavita madam, did you understand?
Yes, sir. Yes, sir. Yes. Yes. Thank you, sir.
Next.
Sir, one more question. Like fitman and FPA.
Pardon? Fitment and FPA.
Yeah, FPA means the fixed personal allowance.
Fixed personal allowance you get only once in your entire career.
In the before
Supposing if you are promoted from class 3 to class 1 and class 3, if you are already got the FPA, that will continue till your retirement. Not in every cadre you will get it.
Yes, I understand, sir. But here is the fitman word.
Fitment is your basic to basic.
There is written as some question is I'm not remember exactly कि fitman पहले लगेगा after the promotion या FPA पहले recover होगा. Something
Fitment कब होता है? नहीं fitment कब होता है आपको? Once you are promoted, then only आपका fitment का question आएगा ना.
Like
That is different.
Fixation and the fitman is the same thing.
Yes, fixation and fitment is the same thing.
Okay, now my answer is resolved. Thank you.
Any other question? If you have no question, then I would like to say something. Can I go ahead?
After a promotion, the fixation your salary and then FPA increment, or first
FPA when you will come to ceiling. So for 3 years you don't get the increment. So after completion of first year, you will be entitled to get the fixed personal allowance, which is equivalent to one basic salary.
Sir, I didn't get understand. Please repeat.
See, supposing if you have reached the ceiling of one particular scale, so after you are not supposed to get the increment for 3 years. Stagnation increment. Stagnation increment that you are not supposed to get for 3 years. But after completing 1 year in that ceiling stage, you will be entitled to get fixed personal allowance. If it has not already been given to in other cadre, that will be equivalent to 1 month's one basic salary, which will remain till your retirement, and that is considered for calculation of DA and your pension, everything.
सर FPA तो आपको पर मंथ मिल रहा है ना,
हाँ तो मिलता है ना, वही बोल रहा हूँ ना मैं. वो पर मंथ में I told you till the end of your career you will continue to get that. मैडम आप एक टाइम पढ़ लेना, आपको समझ जाएगा।
ओके सर, ओके।
और कुछ क्वेश्चन है और विल वाइंड अप।
Sir, are you going
Sir,
to take
regarding
another lecture on HR?
No.
No, sir, because the NPS and old pension means I want to see the difference. Miss, I don't know the new NPS.
The
about
organizer
NPS.
of this program, they had assigned me this work, so I have prepared myself for this. And he's sitting in front of me only. He'll say he'll arrange for that.
Okay, Miss, we want another lecture. Miss, you have taken only CDA rules.
CDA rules, yes.
And other HR is also there, na?
They are trying for the faculty, and you'll definitely get.
Okay, sir. Thank you.
But I think, I mean, this is a complex subject. HR legal, and that's a complex subject because you don't deal with this directly. And even supposing someone is dealing it directly, so that can be one person in RO. So therefore, more clarity is required in IDD. HR legal aspect.
Miss, I want to know about how to calculate pension. Also.
Okay. That he is going to try. Don't.
Okay, sir.
Any other question?
Sir, regarding rule number 18.
What is that?
About employee not to be absent from duty. Na?
Acha.
Who is the competent authority for accepting the medical certificate satisfactory?
No, medical certificate nobody can challenge. It has to be accepted by the head of the office. See, if he's in DO, then divisional manager. Then if he's in branch, then branch manager. If he's in RO personal department, they will accept it. Hey, what is your query? See, what I can gather from your question is that you mean to say some people are in the habit of submitting fake certificates.
No, not like this, sir. As per that schedule for rule number 18, competent authority will be appointing authority somewhere I've seen in that serial rule.
No. It's not there.
Okay. Thank you.
Or can we insist for a report from the medical board in such cases?
Yes, definitely. If you feel that the certificate given by him is not correct, then you can ask him to appear before this civil surgeon to get himself examined and get his report.
Sir, you repeat that order. First investigation, then charge sheet, then.
Yeah. Anyway, I'll be sharing this PPT with you. That's not a problem.
Okay. But
If
now
you want to say,
after charge
I will
sheet,
tell
then
you
order will be.
first investigation, then the report will be given to the disciplinary authority. Then he will decide to issue a charge sheet. Once charge sheet is issued, we will appoint inquiry officer, presenting officer. Then we'll get his inquiry report. Then inquiry report will be given to the charge sheeted employee. Based on his reply, the disciplinary authority will impose a penalty. Once the penalty is imposed, then the delinquent employee get an opportunity to make an appeal before the appellate authority in 90 days. Then supposing even if his appeal has not been satisfactory according to him, then he can prefer a memorial before CMD or board of director or subcommittee of the director. This is the.
Sir, will you give this order in PPT?
This has already been given, na? Or you want this total explanation?
Yes.
Okay, just a minute. See, which is correct sequence as per CDA rules. Can you see this slide?
Yes.
So you can write down, I'll tell you. Investigation. Have you written?
Yes. Investigation, charge sheet.
No. First investigation, then report to disciplinary authority.
Report to
No, see, this was the question, but I am giving you the entire sequence. Investigation, then investigation report to disciplinary authority.
Report to disciplinary authority.
Authority. Then his decision to issue charge sheet.
Decision to charge sheet.
To issue charge sheet.
Issue charge sheet.
Then domestic inquiry by appointing inquiry officer, presenting officer.
Domestic inquiry.
By appointing inquiry officer, presenting officer.
By appointing?
Inquiry officer and presenting officer. Or you can just write down inquiry officer.
Okay.
Yeah. Then receipt of inquiry report.
Receipt of inquiry report.
Then providing copy of report to charge sheeted employee.
Copy of report.
Copy of report to charge sheeted employee.
Then
obtaining his representation.
His representation.
Then deciding about the quantum of punishment.
Deciding.
Or imposition of penalty.
Then
imposition
deciding
of penalty by way of order. Then उसके बाद में order के बाद में appellate authority, appeal, and then memorial.
Okay, sir. Thank you.
और कुछ है question? Okay, then we come to an end of this session, and this PPT will be shared with you all people. So this I am handing it over to the concerned person here, and I have given my email ID and phone number also in case if you find any problem or if you have got any queries, still you can ask me. So how was my presentation? How was the session?
Very good, sir.
Very nice, sir.
Very nice, sir.
Anything has been missed out from my side?
No, sir.
No, sir.
Okay, thank you very much. I hope this will be helpful for you in clearing your examination. All the best.
Thank you, sir.
Thank you, sir.
Thank you, sir.
एक काम बंद करो